Ladies and gentlemen, this is Anindita Hasnain, Training Associate of Bangladesh International Mediation Society, wishing top of the morning to you and greeting you to the second session of Judges Training on Introduction to International Mediation for Chittagong Division, organized by Bangladesh International Mediation Society. Before starting, I am requesting ladies and gentlemen to mute your microphone, turn on your video and be visible. We are overjoyed, grateful and as happy as Larry to have our resource persons. We are very pleased to have Honorable Justice Muhammad Iman Ali Sir, most senior judge, Appellate Division of Supreme Court of Bangladesh as Chief Trainer, and he is the recipient of International Mediation Award. As a resource person of today's session, we have with us Honorable Justice Geeta Mittal, former Chief Justice of High Court of Jammu and Kashmir and recipient of Nari Shakti Puruskar from President of India. Mr. Kevin Berry Brown, PhD, Course Director of BIAMS, Ombudsperson of United Nations and Green Climate Fund IMI, Qualified Assessment Program, IMI Certified Mediation Training Program, President of Mediation International. We have two Honorable Justice Ahmed Sohel, Judge of High Court Division of Supreme Court of Bangladesh, Mr. Tawfiq Mahbub Chaudhary, DIG, VVIP, Protection and Protocol, Headquarter Bangladesh Police, Mr. Veeraraghavan Invabijayan, the International Arbitrator, Ms. Mercy Orkiro, Advocate and Mediator, Ms. Priyanka Chakraborty, Advocate and Accredited Mediator. Without making further delay, here and now, I am inviting His Lordship, Honorable Justice Muhammad Iman Ali Sir, most senior judge, Appellate Division of Supreme Court of Bangladesh, and recipient of International Mediation Award to discuss mediation under Bangladesh law.
Thank you, Anindita. Shobaike, good morning. Assalamu alaikum. Let me share my screen. I think this one. Share. সবাই কি দেখতে পাচ্ছেন স্ক্রিনটা?
জি স্যার। জি স্যার।
স্ক্রিনে কি দেখছেন?
to mediation mediation.
আচ্ছা গুড। ওই পাওয়ারপয়েন্টটা দেখতে পাচ্ছেন তো?
জি স্যার, পাওয়ারপয়েন্ট।
আচ্ছা গুড। আর কিছু তো দেখছেন না, তাই না?
না স্যার।
আচ্ছা, can I just ask all of you whether you have been able to see the guidelines which we have sent to all the judges? ওকে, আমি লিংক দিয়েছিলাম, আপনারা কি দেখতে পেরেছিলেন সবাই?
গতকাল দেখেছি।
আচ্ছা, ইন্ট্রোডাকশন টু মিডিয়েশন। এখন আপনাদের জন্য, বিশেষ করে যারা আজকে ট্রেনিং, আপনাদের জন্য এটা নতুন একটা বিষয়। এর আগে আমরা ট্রেনিং দিয়েছি রংপুর, রাজশাহী, বরিশাল, খুলনা, আর আজকে হচ্ছে চিটাগং। ডিসপিউটস সব জায়গায় আছে, সর্বত্র। আমাদের সারা জীবনেই আমরা ডিসপিউট নিয়েই আছি। বাড়িতে ডিসপিউট, বাইরে ডিসপিউট, বাজারে ডিসপিউট, সব জায়গাতেই ডিসপিউট থাকে। এবং ডিসপিউট থাকে বলেই আমাদের ডিসপিউটের একটা রেজলিউশনের ব্যবস্থা করতে হয়। এবং রেজলিউশন কিভাবে হয়? আগের দিনে যেটা হতো যে দুই বন্ধু যদি কোনো একটা সংঘাতে জড়িত হয়ে যায়, মারামারি পর্যায়ে যখন আসে, তখন ঠিক আছে, সবাই দাঁড়িয়ে থাকে, বলে যে ঠিক কুস্তি করো, যে জিতবে সেই ভালো। তো সেই কুস্তি, ইংরেজদের ছিল ডুয়েল, বন্দুক দিয়ে পিটাপিটি দাঁড়াতো, 10 পা সামনে গিয়ে গুলি করবে, যে বাঁচবে সে জয়ী, আর যে মরবে সে তো মারাই গেল। তো এই ধরনের ডিসপিউট রেজলিউশন এখন আর হয় না। আমরা মিডিয়েশন নিয়ে কথা বলতেছি। মিডিয়েশন কালকে যে কথাগুলি বলেছিলাম, এখন দিস ইজ দি হাই টাইম টু সে দ্যাট মিডিয়েশন ইজ পার্ট অফ আওয়ার লাইফস। বিকজ কালকে যেটা কথা বলা হয়েছিল, উই টকড অ্যাবাউট দ্য রুল অফ ল। জাস্টিস কোরিয়ান জিজ্ঞেস করছিলেন, আপনারা একজনে বলছিলেন, উনি বলেছিলেন যে রুল অফ ল ইজ দি পারপাস অফ দি জাস্টিস ডেলিভারি সিস্টেম, টু এনশিওর দ্য রুল অফ ল। এখন রুল অফ ল, accessibility of the rule of law is the important factor. আমরা মামলা করেই যাচ্ছি। 10 বছর, 15 বছর, 20 বছর, 25 বছর, 30 বছর পুরনো মামলা আমাদের কাছে এখনো আছে। Is that access to justice? That is not access to justice. কারণ justice delayed, justice denied, কালকেও আমরা বলেছি, বঙ্গবন্ধু শেখ মুজিবুর রহমান বলেছিলেন justice delayed, justice denied, এবং এটা আমরা সবাই জানি, মুখে মুখে সবাই বলি। আমাদের দেশে আগে ডিসপিউট রেজলিউশন কিভাবে হইতো এটা আপনারা কালকে শুনেছেন, আজকে আমি আর রিপিট করব না। মিডিয়েশন কেন করব? Because as I said yesterday, mediation is quick disposal, less expensive, and brings about peace. যদিও মিডিয়েশন না, আমি ছোট একটা এক্সাম্পল দিয়ে শুরু করি। আমার কোর্টে একটা মামলা ছিল, 28 লক্ষ টাকার চেক বাউন্স করলো। বাউন্স করার পরে এক পক্ষ 138 মামলা করলো। Those who are non-Bengali speakers, I beg forgiveness. আমার মনে হয়, I think it is better that I speak Bengali to be perhaps a little bit more understood. I will speak, as you said, Banglish, a bit of English and a bit of Bangla, so that I can express myself better. So, 28 লক্ষ টাকার চেক বাউন্স করলো, মামলা হলো, মামলা judgment was against the issuer of the check. He was fined as much as the amounts of the check and also to imprisonment for 1 year. He went to jail. He filed appeal, and you know that he has to put in 50% of the check amount or the fine amount into the court in order to file the appeal. So 14 lakhs paid into the court. He lost the appeal because he couldn't pay. The High Court, when it came to the High Court Division said, I give you 3 months to pay the remainder. If you do, then well and good. If you don't, then you go back to jail. And the judgment stands. He didn't pay. So he went back to jail. He filed a civil petition before the Appellate Division. That is when it came to our court. We asked him if he will pay the rest. He said, yes, but I can't. I want to pay, but I'm unable to pay. So in the meantime, he has to pay, remember, 14 lakhs. But he couldn't pay. But somehow he managed to pay 6 lakhs. And then the complainant came to the court and he said, I don't want to proceed with this anymore. Let him go. And we were a little bit surprised because he is entitled in law to the 14 lakhs. So we specifically asked the gentleman, are you sure? And he said, yes, because he has paid me 6 lakhs more. So that means only 8 lakhs remaining to be paid. And he said, if he goes to jail, I will not get my money. But if we let him free, we are business partners. Not partners, but we are in business together. We have business transactions. So if you let him go, we can continue our business and I can make up that 8 lakhs through our business, which will come. And there you are. It is resolution of a dispute. The complainant is willing to take 8 lakh taka less in order to continue his business relationship, because he knows that if the business relationship continues, he will get much more than 8 lakhs in the days and years to come. Now, that is not strictly mediation. It is, if you like, negotiated resolution, because they have agreed, or he has agreed to settle it. It has been settled outside of the court. But had it been mediated, we could say, yes, mediation has brought peace. But here, the resolution itself has brought peace because the person has agreed to take less and they continue their business. Now, today we have with us judges who can be mediators, assistant judges who are legal aid officers, who do mediation in two forms. I'll get to that in a minute. Yesterday, I talked to you about the good news of the success of the Judicial Reform Committee in getting, first of all, in March, 21st of March, we had the circular. I hope you have all received copies of the circular. You should have, which essentially just simply states what the law says. The law says that mediation in our country is mandatory. Mandatory means you must do it. You must send the case to mediation as soon as the written statement is filed. But the better news yesterday was that we have issued guidelines from the Supreme Court for the benefit of the judges who will send the case to mediation. Those guidelines will explain the attractions and benefits of mediation. That was old. Now, it is very easy for the judge simply to say, the law says to mediate. So you go and mediate. And if the law says that if you cannot mediate, then you will come back to the court and we will continue the litigation. If it is simply put like that, there is no attraction to mediation. It's pointless. The attractions and benefits of mediation must be explained to the litigants and their lawyers, if there are any lawyers. And that is the purpose of the guidelines, which I hope you will have all seen and read. Essentially what it says, that the mediation is confidential. Anything said, discussed, or shown in the mediation will not go back to the court. It is confidential. It is informal. Unlike court or arbitration, parties can talk. In the court, parties do not talk. They talk through their lawyers. In arbitration, again, it is less formal. The atmosphere is less formal. The rigors of the Evidence Act and Procedure Act, Procedure Code do not apply. But still, it is a system whereby the parties are against each other. It is an adversarial system. And the arbitrator is just like a judge, and after hearing both the parties, they will pass an award this way or that way. Mediation is not like that. You will hear from our other colleagues who will tell you what mediation is and how it is not adversarial, how the mediator is simply a go-between, somebody who sits and listens. His part is to listen. His part is not to judge the issues. The parties are in control, meaning that they can choose their mediator. They can allow the court to choose the mediator. They can ask the court itself to mediate. They can choose to have the mediation done through the legal aid officer. It is speedy because the time for the mediation is limited by law. The process must conclude within 60 days. In special cases, it can be extended by another 30 days. And then after that, that is a total of 90 days from the time when the mediator is appointed. And after that, if the parties agree, the agreement is put forward to the court, and the court passes a decree or an appropriate order. And that is final. It is less expensive for many reasons. Number one, mediation can be done through funds available under the legal aid scheme. If of course, the party qualifies for legal aid. Less expensive because less time consumed means less fees for the lawyers. If the case goes on for 25 years, then you're feeding the lawyer for 25 years. If it finishes in one day, that means there's 1 day's worth of work and payment to the lawyer for 1 day. If the mediation is done by the court or by the legal aid officer, there is no fee at all for the mediation, no cost. And if the parties reach an agreement, then the court fees paid to file the suit are refunded. And most important of all, particularly for the justice delivery system, is that once the parties agree, then by definition, they do not need to file any further revision or appeal. They have agreed to cut their losses if there is such a thing. As was said yesterday, it is a win-win situation. Both parties win. Because they have discussed among themselves and somehow or other they have come to an agreement. And that is final. And that is good for the justice delivery system because it saves the parties going further and it saves the system 4 or 5 extra cases which would otherwise ensue. Because as you know, in litigation, one party wins, one party loses. The party who wins celebrates, but not for very long, because the other party will file either a revision or appeal. And they have to go through the process again. And there is further revision to the High Court. Then there is further appeal to the Appellate Division. And then there is review. So there is no rejoicing even for the winner. And it takes so long. Mediators, members of the panel, which is selected under section 89A, subsection 10. Now, unfortunately, I don't think out of our 64 districts, more than half a dozen of the districts have actually got a panel. And that, I think, is the result of lack of awareness of mediation, lack of awareness of the benefits of mediation. I hope that through the exercise that we are doing and the little publicity that we are getting, and hopefully the more publicity that we shall get, there will come a time when everyone will say that mediation is the best process, and therefore they will go through the law and act in accordance with the law. And part of that law is that the district judge, in consultation with the president of the District Bar Association, will make a list of mediators, a panel of mediators. Retired judges can be mediators. Advocates can be mediators. Now here, the proviso is, in my opinion, that they must be qualified. Although, as we say, mediator is simply sitting in the middle, allowing the two parties to discuss their case. It is not so simple, as some the presenters will tell you later on. Mediators have to be good listeners. They have to be good psychologists in order to read the mind of the parties. Which way are they going? They have to control the mediation proceeding. But let me not go into that. Let others talk about it. Legal aid officers are mediators under the law, and any other suitable persons can also be mediators. Now, because it is new, it is not so readily accepted. Now, this slide that you're seeing now was initially it just said age of mediation. And I believe that this is the age of mediation. If countries like Singapore, which has the furthest advanced justice delivery system in the world, if they can say that mediation is the way forward, as I told you yesterday, the Chief Justice of Singapore, as well as the Chief Justice of India, have said very categorically, mediation is the way forward. But then anything new to us is difficult. We feel that whenever we find something new, it must be difficult. And that is what I might call a knee-jerk reaction. You see something new and you think, oh, I can't do it, without even thinking about it. I just refer to one quotation that Sriram Panchu, who is a very famous and well-versed mediator, probably the father of mediation in India. He has in his book quoted from Francis Burnett, where it says, at first people refused to believe that a strange new thing can be done. Then they begin to hope it can be done. Then they see it can be done. Then it is done, and all the world wonders why it was not done centuries ago. Once you know how to do it, once you know what to do, then it becomes easy. And that is the same for mediation. Mediation has been with us for centuries, as we heard yesterday. 4,000 years BC, that's 6,000 years ago, mediation took place. In a different form, we had mediation in our countries, the panchayat, the village elders. So we are going forward. Now, previously I had shown the circular which tells everyone what the mediation process of mediation is within our law. I don't know whether the participants or trainees today have had occasion to see what we had said in our circular dated 21st of March 2021. I would strongly recommend that you please find a copy. I mean, I don't want to spend time going through it here today because that would take a much long time. Similarly with the guidelines, I don't want to spend time with the guidelines because these are written in Bangla and I believe written in simple language which you will understand and which you will be able to incorporate in your work in mediation. Essentially, what I have said already, you just tell the participants, the litigants and their lawyers what mediation is about. Now, one difficult thing to understand, I'll try to explain it. People say that mediation is voluntary. What does it mean? And I'm saying that it is mandatory. Am I saying something wrong? The answer is quite simple. Going to mediation is mandatory. Sending a case for mediation is mandatory. But to resolve the dispute through mediation, to come to an agreement, is not mandatory. Therefore, the parties have to be told, please go and try it. It will be to your benefit. But making sure that they realize that they are not being forced to mediate. In other words, they're not being forced to come to an agreement. Coming to the agreement is voluntary. It's your choice. Because you have been sent by the court to mediate does not mean to say you have to reach the agreement through mediation. You could effectively reach an agreement with only part of the issues and send the rest of it back to the court. You can say that, no, this mediation is no good for me. I want to have litigation. Fine, you go back to litigation. So it is mandatory to send a case for mediation, but there is no compulsion to conclude the mediation into an agreement. I won't repeat what I have said already about what the mediation is and what the judges have to explain. I have already said that. The last thing that I want to say that is on this slide is that litigation and arbitration goes on and on till after review before the appellate division. And that can take between 15 to 20 years. That's a conservative estimate. Sometimes it takes even more. And I can give you an example. In January of this year, we had a case in my court where arbitration, now this was not arbitration through any judges, it was arbitration done primarily through a family arrangement. Arbitration award was given. It was filed. The other side came and challenged it. The bottom line is 17 years after the arbitration award, the matter came before my court, and we found that there was a fundamental error in as much as the other party had not been given notice of the arbitration at all. Now, what is the effect of a judgment if the other party is not given notice and the law requires that he must be given notice? The award had to be set aside. So 17 years gone, arbitration gone, you can go back to the drawing board and start your arbitration again. That is what we had to say. We cannot overlook such a fundamental issue as the party not being notified of the arbitration and not having taken any part in the arbitration at all. Because he deserves to be heard. Every party must be heard. A judgment cannot be delivered in the absence of one party, unless he forgoes, unless he does not want to be a party.
এই বিষয়ে স্যার একটু বলবো স্যার 17 বছর পরে স্যার অ্যাপিলেট ডিভিশনে স্যাটিসফাইড করা হয় স্যার তাহলে রেজাল্টটা জিরো হয়ে গেল। পার্টি স্যার এফআইআর করার সময় আমরা নোটিশ করা হয় সব পার্টিকে, প্রথম মামলায় যখন আমরা নোটিশ করি স্যার যতগুলো পার্টি আছে সব পার্টিকে নোটিশ করা হয়। এরপরে যারা এফআইআর করে তাদের সাথে আরবিট্রেশনটা হয় কিংবা মেডিয়েশনটা হয়। অন্য সবার সাথে মেডিয়েশন হবে না স্যার, কারণ ওরা তো রিপ্লাই দেয় নাই, ওরা তো এফআইআর করে নাই। এক্ষেত্রে যে কন্টেস্টিং পার্টি তার সাথে আমাদের আরবিট্রেশন বা মেডিয়েশনটা হবে। তাহলে ওয়ান পার্টি যে পার্টিটা কন্টেস্ট করছে তার সাথে মেডিয়েশন বা আরবিট্রেশনটা হলো স্যার। সেক্ষেত্রে আরবিট্রেশন বা মেডিয়েশনের রেজাল্ট আসলো ওই পার্টির সাথে যে পার্টি এফআইআর করলো তার সাথে। অন্য পার্টিটা এটা চ্যালেঞ্জ করলো, প্রথম মামলাতে তাকে নোটিশ করা হয়েছিল, তাহলে এটা স্যাটিসফাইড হলে তো ফলো করতে হলো কি স্যার? জিরো হয়ে গেল।
নোটিশ করা হয় নাই তো।
না, প্রথম
বললাম প্রথমেই হয় নাই। আরবিট্রেশন যেটা এটা প্রাইভেট আরবিট্রেশন, আদার সাইডকে নোটিশ করাই হয়নি।
Please, at the time of presentation, don't interpret. Sorry. At the time of question answer will be question.
Okay, thank you.
হ্যাঁ, ঠিক আছে, আপনারা প্রশ্ন অবশ্যই করবেন, লিখে রাখেন, নোট করে রাখেন, পরে একটু। So, mediation, sources of mediation, we have already, I think, heard yesterday. I can just very briefly say that mediation can take place as a result of the clause in a contract which says they will refer to mediation. The mediation by a legal aid officer can be done. Mediation through the court can be done by mandatory or discretionary. We will see that in a minute. Section 89A is the vital law. Section 89A of the Code of Civil Procedure. That makes mediation mandatory. Now, as I said yesterday, in 2003, this provision was introduced, but nobody did anything about it. Nothing happened. But then in 2012, the provision was made mandatory, and still nothing happened. And that is why we are here today. Section 89C makes mediation mandatory even at the appellate stage. So you'll kindly look at the law itself. 89D is a discretionary provision for suits which were filed before 2012. Around 2012, mediation was made mandatory. So any suit filed after 2012, mediation is mandatory. But those suits which were filed before 2012 when mediation was not mandatory, parties can agree to go for mediation. That is discretionary. The Ortorin Adalat Ain, Ortorin Adalat Ain section 22 makes mediation mandatory after the filing of the written statement. And even during the execution of the decree under Ortorin Adalat Ain, mediation is discretionary under section 38. And under section 44 of the said Ain, the appeal, during appeal and revision, again, mediation is discretionary. In the Arbitration Act, arbitration, as you all know, is another form of dispute resolution. But then the Arbitration Act itself says that anytime during the arbitration, if both parties agree, then they have the discretion to take the case for mediation or compromise, etc. And if they agree, if they come to an agreement, it is an agreed award and the arbitration is concluded. So that is why I used to say in my introductory remarks that even the Arbitration Act talks about taking the case out of arbitration, going for mediation. That makes me feel that mediation is a better mode of dispute resolution than even arbitration. Then Labor Act also has provisions for conciliation, mediation, and so on. I don't want to go into detail. You can all find it all. My point of view is very simple. If in any law, if there is a provision which says that the Code of Civil Procedure is applicable, then automatically Section 89A becomes applicable, and automatically the mediation procedure and process is applicable. If you look at Section 17(1) of the Small Cause Courts Act, Family Courts Ordinance is slightly different. There is a pretrial proceeding under Section 10(1) of the Family Courts Ordinance. It talks about compromise or reconciliation by the court. But this, in my view, is not mediation. It is certainly a form of dispute resolution. It is a form of early and quick dispute resolution. And it can be, and it is, in fact, in our country, it is being very effectively utilized to dispose of family cases. Mediation by legal aid officer. This is a special law again, the Legal Aid Act 2000. And that has been subsequently amended. Again, you can look at the law yourself. I will just refer to some very small portions of it. Section 2 The Code of Civil Procedure এবং প্রচলিত অন্যান্য আইনের বিধান অনুসারে মধ্যস্থতা বা সালিশের মাধ্যমে কোনো মামলা নিষ্পত্তির উদ্দেশ্যে নিযুক্ত মধ্যস্থতাকারী বা সালিশকারীকে সম্মানী প্রদান. So, as I said earlier, the cost of the mediator can be provided under the Legal Aid Act. এই মিশনারি চালাইতে গেলেই মুশকিল হয়ে যায়. এই যে সেকশন 21 ক, লিগ্যাল এইড অফিসার আইনগত সহায়তা প্রার্থীকে আইনে পরামর্শ প্রদান করিতে পারিবে এবং প্রচলিত আইনের অধীন কোন আদালত বা ট্রাইব্যুনাল কর্তৃক উহার স্থানীয় অধিক্ষেত্রের আওতাধীন এলাকায় কর্মরত লিগ্যাল এইড অফিসারের নিকট বিকল্প পদ্ধতিতে বিরোধ নিষ্পত্তির জন্য কোনো বিষয় প্রেরণ করা হইলে উহা নিষ্পত্তির ক্ষমতা সংশ্লিষ্ট লিগ্যাল এইড অফিসারের থাকিবে. So there are two things. One is that the legal aid officer deals with cases which come directly to him. So in that case, he is to advise. মামলা আদৌ চলবে কিনা, কিছু আছে কিনা. যদি মনে করেন যে মামলা, there is a point to argue, there is a case to answer, তাহলে আপনার বলতে হবে, হ্যাঁ, there is a case to answer. Should you go to mediation? Mediation কথা বলে দিন. If the party agrees, then you summon the defendant and go through the process of mediation. এটা আইনের মধ্যে বলা আছে কি করতে হবে. Rules আছে, mediation rules according to the Legal Aid Act. Rule 3 within bracket 4 co, case to answer, then you advise mediation. If party does not agree, then you go back to the committee, send the case back to the committee. If the defendant agrees to mediate, then the legal aid officer will himself preside the mediation. You explain to the parties the procedure and benefits of mediation. Again, the guidelines that we have circulated, I hope, will be of assistance to the legal aid officers also. The benefits of mediation must be explained to the parties. One thing that we have to keep in mind always is that whenever parties come to the court, they are in a fighting mode. They want to take blood from the other side, somehow or other. And মীমাংসা করে ফেলেন বলাটা সহজ, কিন্তু সেই গরম রক্তের মধ্যে ঢোকানোটা মুশকিল. So this is where you have to be very careful and expert in explaining to the party, যার রক্ত গরম, যে মিডিয়েশনে গেলে আপনার জন্য সুবিধা হবে, ভালো হবে. কেন ভালো হবে? এই যে মিডিয়েশন প্রসেসটা এইরকম হয়, টাকা খরচ কম হয়, তাড়াতাড়ি নিষ্পত্তি হয়, আপনি মামলা করতে করতে বুড়া হয়ে যাবেন, আপনার ছেলে গিয়ে মামলা চালিয়ে নেবে. যে লয়ার ধরবেন, সে লয়ার মারা গেলে তার জামাই মামলা করবে. এটা বঙ্গবন্ধু বলেছেন, আমার কথা না. So if you can explain the benefits of the mediation process and procedure, costs, the time, and so on, then the party রক্ত আস্তে আস্তে ঠান্ডা হবে. এবং যদি বুঝাইতে পারেন যে মিডিয়েশনটা বেস্ট প্রসেস ফর ইউ, then you have succeeded. So the legal aid officer will advise mediation. Mediation যদি হয়ে যায়, এখানে একটা ডিফারেন্স আছে. লিগ্যাল এইড অফিসারের মাধ্যমে যে এগ্রিমেন্ট হবে, that of course is not a decree because the matter has not come from the court. But the law itself says that the agreement will be a valid legal document under Rule 13(3), and it will be admissible as evidence in any legal proceeding. So obviously the parties who took part in the mediation before the legal aid officer they know that they have come to an agreement and they have signed it. If after that they still go and file a suit, if they're feeling greedy or if they're feeling that they can get something more, then the other side can say, here is the agreement that we arrived at before the legal aid officer. And that will be evidence. And obviously the court will have to take, as a piece of evidence, it will have to take it into consideration. And I think in all probability, when this piece of paper is produced before the court, the party filing the suit will think again whether or not to proceed. Anyway, that is something different. The other duty of the legal aid officer is to do mediation of cases which have been referred to him or her by the court. Because if you remember, at the mediation hearing, if you like, or the fixing the case for mediation, the date for fixing the case for mediation, at that stage, the party has a choice. He can say to the judge, okay, I agree. Or they can say, we agree, you be the mediator. The court itself, the judge himself will be the mediator. And will set a date for mediation, and they will continue and conclude. The parties can say, no, you send us to mediation by the legal aid officer. And this is where the legal aid officer will then sit on the matter being sent to him from the court as mediator. And the decision or agreement that is reached in this mediation before the legal aid officer will then go back to the court, and the court will pass a decree or order on that decision. And one question that was raised previously was that the legal aid officer is an assistant judge. And if the case involved has a pecuniary sum which is beyond his jurisdiction, can he still do the mediation? The answer is yes, he can. Because here the pecuniary jurisdiction is of no relevance, because he is not sitting as a judge. Only when he is sitting as a judge, then the pecuniary limitations will apply to him. Here he is sitting as a mediator. Whatever the amount might be. So there is no pecuniary limit to curtail the jurisdiction of the legal aid officer. Who can be the mediator? As we have said already, I think partly, that judge himself, the legal aid officer, the court-appointed mediator from the panel prepared by the district judge, mediator appointed by the pleader. The lawyers, if they are present, can choose another lawyer, so long as there is no conflict of interest. In other words, the mediator, of course, cannot have any interest in the case itself. He cannot have had any dealings with the case in the past. And it also precludes people like me, who is in the service, earning money otherwise. So the holding of office of profit of service of the Republic, they cannot be mediators. The panel, as I have already said, is to be drawn up by the district judge in consultation with the president of the district bar. And the panel will comprise pleaders, retired judges, persons trained in dispute resolution, and any other appropriate person. And the law does not say how many there is to be in the panel. Fees for the mediator, the court mediator, legal aid officer, no fees. Other mediators, the parties will decide the fees. with the mediator. If they cannot, then it goes back to the court and the court will fix the fees. If the mediation fails, if there is no agreement, then the matter goes back to the court and it will be dealt with. If the court was the mediator, mediation fails, then the case will be dealt with by any other competent judge. Appointment of mediator within 10 days from the date when the mediation hearing takes place. Not the mediation takes place, but the hearing date for sending the case to mediation. In other words, after the filing of the written statement, a date will be fixed when the court will summon all the parties and say, we want to send the case for mediation because the law says so. And then he will detail all from the guidelines that we have sent or the benefits of mediation, etc. are. And within 10 days of that, the parties must decide on a mediator. If they do not, if they cannot, then the matter goes back to the court, and within 7 days from that, the court will decide and appoint a mediator. As I've said already, mediation must be concluded here. So, although we say that 90 days, it is 90 days from the appointment of the mediator. Here is a slight difference between this mediation under the CPC and mediation under the Orthorin Adalat Ain. Because under the Orthorin Adalat Ain, the time is even less. And the mediators are slightly different. I think I have a slide on that later. So 60 days plus 30 days. When the results are sent back to the court, there is a written agreement signed by the parties and witnessed by the lawyers. Within 7 days, the court will pass a decree or an order, and also pass an order for refund of the court fees that have been paid. There is no appeal against or revision against the decree of the court. This is obviously the best advantage, so far as the justice delivery system is concerned, of mediation, because, as I said earlier, it reduces the number of cases that come into the system fourfold. And certainly, if both parties have agreed, then, as we said earlier, peace is obtained, and there is usually no scope for any further dispute. Again, I think this is just repetition. Mediation mandatory in the appellate court. Again, it can be mediation by the court itself or referred to a mediator. Arbitration Act. Just want to say quickly about the Arbitration Act, Section 22(2). If settled by mediation, parties apply to arbitral tribunal to record settlement from the arbitral award on agreed terms under Section 38. The award is binding but can be challenged. You see, this is the problem with arbitration. The arbitration award can and very often is challenged. Orthorin Adalat Ain. Here again, as I said earlier, under Section 22, the filing of the written statement, referral is mandatory. It is the referral which is mandatory. Under Section 22(2), mediator by mutual agreement from independent pleader, retired judge, retired bank, retired official of a bank or financial institution. This is the difference between the Orthorin Adalat Ain and the CPC. Here we have another category of mediator which is not available under the CPC, and that is an official of a bank or financial institution. And I think that makes sense because you are dealing with cases of financial institutions under the Orthorin Adalat Ain, And therefore, somebody with knowledge of financial institutions and banking would be probably more appropriate as a mediator. The fees are fixed by the parties, and if there is an agreement, then the signature of the parties and in terms of the agreement. Inform the court within 10 days of appointment of mediator. In default, the court will appoint the mediator, similar to the CPC. Time limit, again, mediation 60 days plus 30 days. Order or decree in terms of the written agreement, and if the mediation is successful and results in an agreement, then again the parties will get back their fees, court fees. No appeal and revision. And I think that makes sense. Mediator's job is to listen, as I have said earlier. I think I have said all I want to say, apart from the fact that, as I said yesterday, we want to make people aware of how good the mediation scheme is. So, what we have done through the guidelines is given a cue, an indicator to the judges who will send the case for mediation to tell at least the litigant public who are before them and the lawyers who are before them the benefits of mediation. So automatically we have a group of people who have become aware of mediation and the benefits of mediation. And what I have suggested is that copies of these guidelines may be handed over to the parties and their lawyers at the time of sending the case for mediation. Because as often happens, just like I'm talking to you today, you're listening to me, but something is going in and everything is coming out. So nothing is staying in. That may happen. So similarly, when you talk to the litigant public and send them to mediation, they may not realize exactly what you are saying. They may not understand fully what you are saying. Although obviously as judges, you will tell them in the best language that the benefits are there. But then the lawyer may say something different to them. And here we have an uphill task of making the lawyers understand that mediation is not taking away their cases. It's bringing them more cases, I would say. Because if the lawyer can dispose of a case in 1 day or 2 days, he will dispose of 10 cases in a week. And he will become renowned, reputed as a lawyer who can bring justice quickly. And more cases will come to him. But then we have to make the lawyer aware to the benefits of mediation to him also, not just to the parties. So only a group of people, the litigants and the lawyers, will be made aware through the judge giving them a copy of our guidelines and telling them all about it. But I believe that it is time that there is a publicity through the whole communities, the general public, about the benefits of mediation. The saving of cost, simplicity of procedure, the speed, informality. And as a judge of the Supreme Court, I cannot go to the media to publicize all of this. But I hope that others who are in a position to use the media to publish and make public the benefits of mediation, I hope they will do so. Because in the long run, what are we doing? We are making the justice delivery system more accessible, easily accessible, cheaper for the litigant public. And if they appreciate that, if the public appreciate the benefits of mediation, then I believe we have a method of dealing with cases which will, in the long run, be of benefit not only to the litigants, but to the judiciary, and as a result, to the whole of the country.
Introducing SpeechLove.
And as I said, I want to say very finally, I want to say very clearly that mediation that we have talked about today is in-country mediation. A time has come for us to also think about international mediation, mediation between the state and foreign investors, for example. And this is where I believe that we will need to have different and further laws in order to accommodate the agreements between our state and foreign investors, or investors of our country who go into joint ventures with investors of foreign countries, etc. There will be all different connotations and commutations which will be there. But law to cater for that has to be in the pipeline, has to be done. And moreover, as I said yesterday, we have to consider signing the Singapore Convention in order to be able to enforce any mediation agreement that are reached in the international mediation arena. So I will stop here and I'll ask if there are any further questions by anyone. Unless you want to leave the questions until later, I'll leave it to you, Anindita, how you want to.
Lordship, I have a question.
Yes.
About mediation in অর্থহীন আদালত আইন। আমার বাস্তব জীবনের একটা তথ্য আমি তুলে ধরছি লর্ডশিপ। এটা হলো যে আমাকে মেডিয়েশন নিযুক্ত করা হলো কোর্ট থেকে। আমি দুই পক্ষকে নোটিশ দিলাম, দুই পক্ষের এক পক্ষ আসলেন আর এক পক্ষ আসলেন না, না আসায় আবার দ্বিতীয়বার তাকে নোটিশ দেওয়া হলো, একটা ডেট দেওয়া হলো। আমি কোর্টকে ইনফর্ম করলাম লর্ডশিপ, ওই ডেটে ওই এক পক্ষ আসলেন আর এক পক্ষ আসলেন না। আমি আবার কোর্টকে এটা ইনফর্ম করে আবার নোটিশ দিলাম, তিনবার নোটিশ দেওয়ার পরেও তারা কেউ আসলেন না। তখন কোর্ট তখন উইথাউট মাই অপিনিয়ন উনি অ্যানাদার ইসে চলে গেলেন। লর্ডশিপ, এখানে আমার একটা সাজেশন হলো, যদি এটা অ্যাপ্লিকেবল হয় লর্ডশিপ, আপনি এটা বিবেচনা করবেন। সেটা হলো যে এই যে ফি এর ব্যাপারটা, ফিস, এইটা যদি পার্টি দিতে চায় না, কারণ পার্টি আসে না বিধায় যদি কোর্ট এটাকে ম্যান্ডেটরি করে দেয় যে এই মেডিয়েশনের জন্য যে পার্টি আসবে না সে সমস্ত খরচ বহন করবেন অ্যাডভোকেট সাহেবের, মেডিয়েটরের। লর্ডশিপ, আমার মনে হয় এটা যদি করা যেতে পারে তাহলে মনে হয় আমাদের একটু অ্যাওয়ারনেসটা বাড়বে পার্টিদের ভিতরে। না হয় কোনোভাবেই এরা আসে না। যেমন সিভিল লয়ে সেম ঘটনা লর্ডশিপ, আমাকে সেখানেও একটা মামলায় মেডিয়েটর নিয়োগ করা হলো। আমি দুই পক্ষকে নোটিশ দিলাম, ডেট দেওয়া হলো, এক পক্ষ আসলো না, সেকেন্ড টাইম নোটিশ দিলাম, তারাও আসলো না, থার্ড টাইম নোটিশ দিলাম, তারাও কেউই আসলো না। আমি কোর্টকে ইনফর্ম করলাম, বাট আমি যে আমার সময়টাকে লস করে তাদেরকেই করলাম, নোটিশ দিলাম, করলাম, এখানে আমার তো কোনো কিছু আসলো না। এভাবে করে মেডিয়েটরদের ডিপ্রাইভ করা হয় বলে এখানে কেউ আসে না, লর্ডশিপ আসতে চায় না। এবং এই ফি কি, অ্যাডভোকেট সাহেবরা তো ফি এর জন্য লর্ডশিপ একটা করেন, তাই না? সুতরাং এই জিনিসটাকে যদি সেইভাবে কোনো ভাবে যদি এই ফিটাকে কোর্টের মাধ্যমে একদম করে দেওয়া হয় যে হ্যাঁ আসুক বা না আসুক এত টাকা ফি দিতেই হবে, আমার মনে হয় এটা আমার সুবিধা হয়।
আমি আপনার কথা বুঝতে পেরেছি, বাট এখানে একটা সমস্যা হলো যে আইনের মধ্যে বলা নাই যে ফি ইন অ্যাডভান্স নিতে হবে বা দিতে হবে, এক নম্বর কথা। দুই নম্বর কথা হলো যে এখানে আরেকটা, আপনার এর আগে যেটা বলেছি এটা আবার রিপিট করি, সেটা হচ্ছে যে মিডিয়েশনের পাঠানোটা হচ্ছে ম্যান্ডেটরি, বাট মিডিয়েশনের মাধ্যমে মামলা নিষ্পত্তি করাটা ম্যান্ডেটরি নয়। সুতরাং সাপোজ দুই পক্ষ প্রথম দিন আপনার সামনে হাজির হলো, এরপরে বললো যে না আমার মিডিয়েশন দরকার নাই, কোর্টে যাই, তখন তো আপনার কিছু করার নাই, এবং তখন মিডিয়েশন হইলই। হ্যাঁ, তো আসেই নেই, তো এটা হলো ওই যে আমার মতে যে এইটা এই মুহূর্তে এটা হচ্ছে এই কারণে যে the benefits of mediation have not been explained properly to the parties. এটা এর আগে কখনো হয় নাই। যাও বাবা মিডিয়েট করে চলে আসো, মিডিয়েশন করো তো চলে আসো, না হইলে চলে আসো। তো না হইলে চলে আসো মানে যাওয়ার দরকারই কি, যাবই না।
যেমন ধরেন ব্যাংক কখনোই মেডিয়েশনে আসে না,
এটা একটা প্রবলেম আছে। ব্যাংক মনে করে যে আমাদের তো
কখনোই আসে না,
আমাদের তো একটা কংক্রিট ক্লেম, আমাদের ক্লেম তো কমাইতেই পারবে না।
হ্যাঁ,
সুতরাং মিডিয়েশনে যাওয়ার মানে কি আমার পুরোটাই পাবো। তো এইখানে এখানে হচ্ছে কি এক্সপ্লেনেশনের ব্যাপারটা, গাইডলাইন হচ্ছে যে বুঝাইবার ব্যাপারটা, এখানে হচ্ছে ব্যাংকে এটা বুঝাইতে হবে যে দেখো, হ্যাঁ মিডিয়েশন গেলে তোমার টাকাটা পুরোটাই এমনি পেয়ে যাবে কোর্টে গেলে, ঠিক আছে, কিন্তু কোর্টে গেলে 10 বছর লাগবে, 15 বছর লাগবে। তোমার এই যে 10 লাখ টাকার ক্লেম 15 বছর, এখন যদি 10 লাখ টাকা পাও, এখন যদি 8 লাখ টাকাও পাও, এই 8 লাখ টাকা বেটার নাকি 10 বছর পরে 15 লাখ টাকা পাওয়া বেটার?
সেই জন্য আমি বলছিলাম যে সেকশন 22(3) এইটাকে যদি একটু অ্যাড করা হয় তাহলে মনে হয় ভালো হয়, তাহলে মিডিয়েটররাও পাবে না আর কি।
মানে আপনি তো আপনার চিন্তায় আছেন
না, আমার চিন্তা
আপনার টাকাটা কেমনে হলো, আপনি তো কোনো কিছু করলেন না।
আমি তো নোটিশ দিলাম।
হ্যাঁ নোটিশ দিলেন, একটা চিঠি দিচ্ছেন,
হ্যাঁ চিঠি দিচ্ছি।
কত সময় ব্যয় হয়েছে, কত টাকা খরচ হয়েছে,
আমি তো
আসল কথা হচ্ছে যে এই যে ইভেন দ্য ব্যাংক শুড বি মেড টু আন্ডারস্ট্যান্ড যে মিডিয়েশনে গেলে আপনার 10 লাখ টাকার ক্লেম যদি আপনি 9 লাখ টাকাও পান আপনার জন্য বেটার। এই জিনিসটা যদি বুঝাইতে পারে জাজ সাহেব মিডিয়েশনে পাঠাবার আগে, তখন আমার বিশ্বাস আস্তে আস্তে ব্যাংকগুলো মিডিয়েশন করতে রাজি হবে।
স্যার আমি একটু স্যার অ্যাড করি স্যার এই বিষয়ে। আসলে স্যার এই মিডিয়েশনটা স্যার আগে থেকেও ছিল, এখনো আছে। বিষয়টা হচ্ছে স্যার আমাদের মানসিকতার পরিবর্তন যতক্ষণ পর্যন্ত হবে না, আমরা অভিভাবক উইন-উইন সিচুয়েশন যখন স্যার ডেভেলপ করবো ততক্ষণ যেটা ফলাফল আসবে না স্যার। কারণ হচ্ছে মামলায় যখন যায় তখন কোনো একটা পক্ষ স্যার সুবিধাজনক অবস্থানে থাকে, বাদী হোক বিবাদী হোক। যে পক্ষ সুবিধাজনক অবস্থানে থাকে সে পক্ষ চায় না ফলাফলটা তার বিরুদ্ধে চলে যায়। এই কারণে সে স্যার এই অ্যাডভার্সারিয়াল সিস্টেম সম্বন্ধে জানা থাকা সত্ত্বেও এবং অ্যাডভোকেট বা অন্যান্য সবাই আমরা অ্যাডভাইস করি তুমি তো ভালো অবস্থানে আছো, তোমার নড়চড় করার দরকার নেই। এই যে আমরা মানসিকভাবে স্যার যে চেঞ্জ হবে না, আমরা দর্শকটা সবসময় বলি যে এটা আপনার তাড়াতাড়ি দ্রুত করতে হবে, আপনাদের মধ্যে ভালো সম্পর্ক হবে, ফলাফলটা ভালো পাবেন। এই জিনিসটা তারা মাথায় ঢুকাতে চায় না স্যার। যেমন ব্যাংকের পদ্ধতিতে ব্যাংক কখনো স্যার আসে না, আলোচনার মাধ্যমে নিষ্পত্তি করে কিছু টাকা কম নিয়ে আমরা শেষ করি। আর ব্যাংকের কর্মকর্তাদেরকে এই অথরিটি দেওয়া হয় না যে তোমরা কমিয়ে ফেলবা বা সিদ্ধান্ত নেওয়ার সুযোগটা দেওয়া হয় নাই। এটা বোর্ড অফ ডিরেক্টর পর্যায়ে চলে গেছে, বলে যে ডিসিশন আসলে ওরা দিবে। এমনকি সুদ কমানোর ক্ষেত্রেও স্যার যদি বলে যে কিছু সুদ কমিয়ে দেন, কিছু সুদ কমানো হোক, সেটাও তারা পারে না স্যার। এটা ব্যাংকের অর্থনৈতিক আদালত সম্পর্কে।
এখানে টেকনিক্যাল প্রবলেম গুলি আছে, শুনে লেট মি কাট ইট শর্ট, কারণ এত আপনার প্রশ্ন নাই। এখানে কথা যেটা, এই ইনফ্যাক্ট আমি কালকে বলি নাই, এই ইংল্যান্ডের যে কথাগুলি বলছিলাম কালকে, যে তারাও এখন ম্যান্ডেটরি মিডিয়েশনে যাওয়ার চিন্তা ভাবনা করছে, তারা কিন্তু একটা জিনিস তারা চিন্তা ভাবনার মধ্যে রাখছে যে মিডিয়েশনে আসবে না তার বিরুদ্ধে কস্ট দেওয়া হবে কেসে। এমন এটা তো মুশকিল হয়েছে, এটা আমাদের আইনে নাই। অদূর ভবিষ্যতে এটা হয়তো আসবে, যখন আমরা দেখব যে এই ব্যাংকগুলি আসতেছে না, তখন আমরা হয়তো এমন এক পর্যায়ে যাব যখন আমরা বলতে পারবো যে মিডিয়েশনে যাও নাই, সুতরাং ইউ বেয়ার দ্য কস্ট। মামলা হারলে ইউ বেয়ার দ্য কস্ট, এমনকি মামলা জিতলেও ইউ বেয়ার দ্য কস্ট। কারণ তুমি যদি 10 লাখ টাকার কেস করো, কোর্টে গিয়ে 10 লাখ টাকা পাও, দ্যাট মিনস ইউ কুড হ্যাভ গন টু মিডিয়েশন এন্ড গট ইউর মানি, and you didn't go to mediation, you have wasted court time, so you pay costs. So this is something that has to be developed. It cannot be developed overnight. Is a Bengulike convince kora, again it will have to be developed over time. এই যে গাইডলাইন আমরা দিলাম, এগুলো যদি ভালো করে জজ সাহেবরা বোঝাই দিতে পারেন, ব্যাংকে যদি বলেন যে আপনি 10 লাখ টাকা এখন পাবেন, কিন্তু 10 বছর পরে আপনার 10 লাখ টাকা পেয়ে আপনার কোনো লাভ নেই, এই কথাটা যদি মাথার মধ্যে ঢোকানো যায় একবার, তখন ব্যাংকগুলিও আসবে। আর আমি বিশ্বাস করি যে হ্যাঁ, আলটিমেটলি আমার মনে হয় এই ধরনের যারা আছে, যারা ওই অ্যাডভান্টেজ নেয়, তাদের বিরুদ্ধে কস্ট দিতে পারলে তখন গিয়ে আস্তে আস্তে জিনিসটা ঠিক জায়গায় আসবে আমার বিশ্বাস।
Thank you, sir, for the incredible, enlightening, and flawless presentation. A million sincere thanks to you for the sea of wisdom and knowledge you showed us during your presentation. It was a very communicative session. At this point, I am humbly inviting Mr. Kevin Berry Brown, PhD, Course Director of BIMS, Ombudsperson of United Nations and Green Climate Fund, IMI, Qualified Assessment Program, IMI Certified Mediation Training Program, President of Mediation International, to discuss the role of mediators.
Hi, thank you. I'm just setting up here. It'll take just a second to get the screen up. There we go. Well, thank you. Thank you very much. And Anita, thank you for the kind introduction. Justice Inman, it's great to see you again, sir. It's always wonderful to hear you speak. I am honored to be here today to speak with all of you, the judges, lawyers, mediators, learned colleagues, other participants, and of course, now I would love to be able to, as my colleague just did, speak to you in English. Unfortunately, I can only speak in English. I live in Spain, so I could possibly say some things in Spanish, but I doubt that would be a great help. I'm going to talk to you today about the role of the mediator and how that role can change during the different stages of mediation. Just as Emin mentioned earlier, that sounds, being a mediator can sound like it means you just sit in the middle of other people and help them resolve their conflicts and let them talk. And it is more than that. It is considerably more than that, as you will find out when you begin mediating, if you haven't already. I've been mediating myself for well over 30 years as a mediator and or as an ombuds. My name is Kevin Brown. I was already introduced to you, and I've worked in various fields. I started off in family, divorce, inheritance types of mediations. I then worked in workplace, civil, commercial mediations, international mediations with the United Nations. I also work with the Green Climate Fund as an ombuds in Korea. Because of COVID, I don't go to Korea, but I do it from my home here in Madrid. And actually, to be honest with you, I'm not in Madrid right now. In July and August, the temperatures hit over 40 degrees Celsius, so it's quite hot. Weather I'm sure you folks are also aware of. So we escape to the mountains, and when I came up here in July, I forgot to bring a jacket or a tie. So I apologize that I normally would be wearing a tie and a jacket for our presentation to you folks. But I just looked through the house and I could not find one. Today we face so many challenges in mediation, with social distancing, with COVID, with the work from home dynamic that's going on. There's a lot of other conflicts that have come up, that have begun. And in the past, the role or the stages of mediation have been broken down into 4, 5, 6, 7, sometimes 8 different stages, depending upon the mediator. I'm going to show you the stages that I use. Different mediators use different stages. So you may have, or you may still see another version of the stages of mediation or the mediation process overview. The information I'm going to share with you in just a few moments is the same information that I share with non-judges, non-lawyers. It applies to any type of mediation that you do, whether you have legal background or not. As judges, you'll probably know some of this information already, and for others, it will be new information. So this might be a reminder or new information. So today we have limited time. So let's begin. I'm starting with this slide here, as I mentioned, just to show you my 5 stages of mediation. This process focuses on civil and commercial mediation, yet it could be used in a variety of other different types of mediation as well. The mediator has specific roles in each of the 5 stages. In the pre-mediation stage, that's where most of my work is done, to be perfectly frank. I spend a great deal of time in the pre-mediation stage getting both the participants and oftentimes the lawyers prepared to listen to the other side. For having people come into mediation when all they want to do is talk and fight is not what a mediation is all about. People need to be able to listen non-judgmentally to the other person. The initial joint session, that's also exceptionally important. And it lets the parties formally understand the process. All the roles, what my role is, what their role is, what their lawyer's role is. My preference is that the individuals do most of the talking. I prefer to hear people say what's happened in their life as opposed to the lawyer say, my client experience, et cetera, et cetera. Now, the joint session, I will go into more details shortly. This is just an overview. The joint session, once the first initial session is over, I as a mediator or you as a mediator make a decision on whether or not you're going to have a joint session. There's many advantages and disadvantages of doing that, and we'll talk about that shortly. The caucuses, I'm sure you're all familiar with what caucuses are. Oftentimes, the caucuses or the private sessions provide the opportunity for the mediator to help the parties become more reasonable, to find out from the parties what the underlying reasons are, and to help them speak or discuss issues with the mediator that they don't necessarily want to share with the other party. Final stage is the closure. And there's really 3 main types of closures when I'm doing mediation: fully resolved, partially resolved, or not resolved. And hopefully most of them are in the first 2 categories. So let's just talk about the role. Now, the role is pretty straightforward. It's facilitating the discussion between the parties, helping the parties to reach a satisfactory outcome in the spirit of trust. Mediator does not take sides. He or she does not judge who is right or who is wrong. The mediator simply creates the opportunity for the parties to have a constructive and collaborative dialogue, and provides professional, neutral, and independent assistance for the parties. Now, to expand on that a little bit, what makes a mediator successful? Well, there's a lot of studies that have been done, and a lot of experienced mediators will tell you why they have become successful. And research has attributed that mediator's success globally and domestically to 3 specific factors. 1, the mediator allows the parties to deal with issues that they themselves feel are important. It's not important what the mediator thinks is important. It's important what the parties feel is important. Second part is they allow the parties to present their views fully, give them the time and the space to be able to present what they have to say. And thirdly, they give the parties a sense of being heard. Listening, as my learned colleague just moments ago said, is very important. Probably the most important aspect is the amount of listening that you will do. People need to be heard before they're ready to be able to participate in a collaborative discussion. And as a mediator, you get to show all of your mediation skills of paraphrasing, reframing, summarizing what you've heard the parties say. And there's a couple of real solid, valuable reasons to do that. 1, to make sure that you know or you understand what the parties have said, what party has said. 2, to let the party who is speaking understand completely that he or she has been heard by you. And thirdly, oftentimes when one party is speaking, the other party may be trying to listen, but oftentimes you'll see the lawyers scratching down notes or making notes of some sort. And oftentimes the other party is really thinking of what they're going to respond and what their response is going to be, instead of actively listening to the party speaking. So by paraphrasing and reiterating what you've heard, you're giving that other party an opportunity to hear again what the first party was saying. So that's the research on the mediators. The research from the parties themselves in the same study showed that there were 2 main reasons that people had favorable attitudes towards the mediation process. First is the greater degree of participating in the decision making. A judge or an adjudicator is not making the decision for them. They are part of the decision making process, and the greater opportunities to express themselves and communicate their views. Several studies have revealed that informal mediations that lack the features that I just mentioned result in lower success and satisfaction rates. Plus, in my 30 years of experience, every conflict that I have been presiding over has at its core an undeniable emotional element. Lawyers and most other professionals involved in conflict management typically believe that disputes are managed through the use of rational decision-making and objective reasoning. However, when a group of experienced mediators were asked what they wished that they were taught during their mediation training, the vast majority said that they wish they had detailed techniques for responding uniquely to each negative emotion, such as fear, anger, shame, jealousy, pain, grief. Methods for increasing emotional intelligence, ways to become more aware of and responding to the energies and vibrations in the conflict between the parties. Methods for opening heart conversations and knowing how to strike the right balance between head and heart. Now, a colleague, Kenneth Cole, he's an author. He wrote a book called Building Bridges Between Psychology and Conflict, Implications for Mediator Learning. Absolutely amazing book. If you have a chance to read it, I highly recommend it. So, with this research and the history, we can recognize that experienced mediators found it near impossible to separate the emotional drivers behind a conflict from the facts. Conflicts can only be resolved if the underlying emotions beneath them are identified and addressed. This requires mediators to be emotionally literate and possess a degree of what is described as emotional intelligence. David Goleman is the initial author of Emotional Intelligence. A lot of books have come out after his initial one. An emotionally intelligent mediator must develop 4 skills: the ability to identify one's own emotions and those of others. Identification is most important. The ability to harness emotions and apply them to tasks such as thinking and problem solving. The ability to manage emotions, including the ability to regulate the mediator's own emotions. One has to ensure that they don't get so wrapped up in a situation that they become emotionally engaged in the mediation. And the ability to affect the emotions of others in the negotiation and the negotiation process. Now, there's a mediator's code of conduct, and that varies depending upon where you are, which culture, which country. So I would imagine that there is a code of conduct in Bangladesh. In some countries, it is mandatory, and others, it is not. Mediation in many countries is an unregulated profession, so there are principles that people follow. I'm not going to go through in detail these principles. I believe you've already spoken to voluntary and impartial, independent. There shouldn't be, recognizing any potential conflict of interest you might have, confidentiality and the importance of confidentiality. I also put organizational down here as well, because depending upon which organization that you belong to, for example, I'm part of the International Ombuds Association, and we have our own code of ethics, standards of practice. And I also mediate for the United Nations, Green Climate Fund, and the European Space Agency. And in those organizations, they have terms of reference, which define the parameters that an ombuds or mediator can work. And sometimes there can be conflicts between the two sets of code of conduct. So it's something that's very, very important, depending upon the type of work that you're doing. So, okay, now the mediation agreement process and settlement. The mediator's role is to ensure that the parties in the mediation understand the characteristics of the mediation process and the role of the mediator and the parties and the lawyers within the process. The mediator must, in particular, ensure that prior to commencement of the mediation, the parties have understood and expressly agreed to the terms and conditions of the mediation agreement, including any applicable provisions relating to obligations of confidentiality on the mediator and on the parties. In my particular practice, I send out the agreement to mediate to people ahead of time. I don't want anybody to feel pressured on the day of the mediation to sign an agreement. They all have it. They all have their lawyers look it over, and they all agree to it, or I don't proceed with it with the mediation. The agreement, in my case anyways, is normally a written document signed by all of the participants. The mediator must conduct the procedures in an appropriate manner, of course, taking into consideration the circumstances of the case, including possible imbalances of power. And if one party shows up with 3 lawyers and the other party has no lawyers, and any wishes that the parties may express, the rule of law, the need for a prompt settlement of the dispute, of course, are factor in. Fairness of the process. The mediator's role is to ensure that all parties have adequate, appropriate opportunities to be involved and to be heard in the process. The end of the process? Well, the mediator must take all appropriate measures to ensure that any agreement is reached by all parties through knowing and informed consent, and that all parties understand the terms of the agreement. This is much easier when the parties have their lawyers present, but that's not always the case in my experience. The parties may also withdraw from the mediation at any time without giving any justification. Remember, I mentioned the voluntariness of it, and I believe I heard Justice Inman mention as well the voluntary component. In my situation, I always ask the parties at the very beginning of the mediation that if they wish to leave at any point for any reason whatsoever, please do not just walk out in anger. Commit to giving me 5 minutes in private with the person prior to leaving. So I will then go out and meet with that party who wants to leave, have a conversation, and if they still decide they want to leave, so be it. They have that right. Oftentimes, they have the opportunity to settle down and to come back into the mediation room. That caucus is very important, but equality is also very important in my opinion. If I do have that caucus with one party, I will bring them back into the mediation room and I'll have another caucus with the other party, seeing where they stand, where they're sitting at that particular point in the mediation process. Okay, I mentioned the different steps, and I told you I'd go through them, or stages. I'd go through them. There's a lot of information on this slide, so I'll give you a moment to read. As I've already mentioned, I spent a lot of time in the pre-mediation phase. And as you'll see in point 2, yes, I do charge for these consultations. I have no idea how it works and how you're able to charge in Bangladesh. But in my world, if I'm working, I'm billing. Understand that the procedural issues of a case, find out about any special circumstances which may affect the mediation, any client control or client expectation issues, determine whether or not there's an unbalanced view by one of the or both of the parties or counsel about weaknesses or problems of their case. These are all areas that you're able to do before the mediation even starts. This information will assist you greatly in the mediation. You prepare to advance to address, when you prepare in advance to address the legal, factual, and practical arguments and counter arguments to issues that will likely come up during the mediation. My greatest recommendation here is to think as deeply about legal or litigation issues as if you were still acting as a lawyer or a judge. Read in advance all the important materials, the pleadings, the court rulings, the orders of legal authority, contracts, depositions, hearings, transcripts, or any other hot documents. There will not be enough time to go through all of that material in the actual mediation itself. So ask for and study, as I mentioned, the mediation submissions. Counsel and the parties cannot easily explain at the mediation all of the details, dynamics, factual, substantive, procedural, evidentiary issues in a case, which, quite frankly, may have been litigated for 2 to 3 years, involving potentially millions of dollars. If pre-mediation statements are provided, study them diligently. That is a huge part of your role before the mediation even begins. The party representatives, make sure in advance that the parties bring the right people to the mediation with them. I always discuss with the parties, with the lawyers ahead of time, who's going to be at the table, who has the decision-making power, and if they don't have it, do they have easy access to that person? Make sure that schedules are cleared and the parties are aware of how much time the mediation will take. The worst thing in the world is to be 2 hours into a mediation and somebody says, I have to leave. I have another meeting now. Poor planning, and then it just becomes a disaster, or it takes up a great deal more time than would be necessary. And I find that oftentimes, I'm sure many of you will agree, that at the final hour, solutions come quickly. There's a lot of debating during the day, but then when we're running out of time, people start to really focus in and come up with potential solutions which can make or break, the situation. Remember, this is your opportunity to encourage, counsel to use mediation as an opportunity to evaluate or reevaluate their client's case and to educate their client. Encourage them to take advantage of this natural platform and event to review the case development, its current strengths and weaknesses, and practice the economic and practical economic issues. Encourage the council also to use your help as a mediator with client control or expectation issues. Now, the actual opening session or the mediation itself, this is my room setup. Certainly you're able to set up your room any way that you like, but I like the parties right beside me. Beside them are the lawyers, their lawyers, and other attendees and any witnesses if they have them, or any experts if they need them. I often don't have experts, but if they're there, they don't play a continuous role. They play a key role, but not a continuous role. And remember, you as the mediator, you control the process. You don't control the people, but you control the process. So what I do is I put names on the chairs or the tables in front of chairs so people know where to sit. I've had lawyers move the tags around, and I stopped them immediately. Say, no, you're in the wrong spot. Please take your allocated spot. I just think this makes a lot of sense for me. This seems more natural for me, and it works. So, stage 2, the opening joint session. This is when you're bringing the people together. Might be the first time that they've been in the same room for a long time. It starts off with the mediator's opening statement. After the disputant or the parties are seated at the table, the mediator's role is to introduce everybody. He or she explains the goals and rules of the mediation and encourages each side to work collaboratively towards a settlement. Now, oftentimes, mediators think that they can skip their opening session because, lawyers are here, I don't need to do it. They know the whole thing. They know the routine. Big mistake. I highly, highly recommend that you, each and every time you do your opening statement, it helps to build trust. It lets everybody know the goals and objectives of the mediation. You can answer any questions that people might have. And most importantly is that trust and relationship aspect with the parties, making them feel more comfortable sharing information with you, either in the sessions or in a caucus. If they don't trust you and you haven't worked on that relationship building, then they're not going to be upfront, they're not going to be open, and the information that you need will not come out. You explain what the mediator's role. You're there to help them settle the case, basically, to create and keep momentum, to change people's perspectives about the case, to determine the parties' true views about the case, to be the voice of reason, to be objective, sometimes to temporarily stop the mediation when someone is obviously lying, not being honest. In Europe, we call it chest thumping, in this case, it's most often it's of the lawyers that are doing that are exaggerating their case, their grandstanding, and that is more confrontational than I want it to be. So I'll stop that, have a caucus, have a break, explain that this is not what we're doing. This is not a trial in court, and bring them back to a more realistic and collaborative approach. This isn't always an easy thing to do, so I will do it oftentimes in caucus. Now, remember, the mediator is not there to be a judge or an arbitrator. You're there to help them make the decisions. We don't make decisions for them. And that's where the dynamics of private caucuses with the mediator and confidentiality can come into play. I like to inquire about the participants' logistical issues. Even the most inexperienced non-lawyer client should be aware that they should plan on a long day, make sure they have no commitments, that if there are others that need to be contacted, that they have ready access to them, that they will need to be patient to listen to what the other person is saying. Oftentimes they will hear something they don't agree with. Piece of paper, pen, they can feel free to take notes, but not to interrupt. That even if the case does not settle on that particular day, the mediation is not wasted. It's an opportunity to obtain and give a lot of information and may well set the foundation for a future settlement. In your opening statement, you should focus on developing a friendly working relationship with the parties. Now, I'm not suggesting that you become their friend, but you do need to build trust. And if you want them to work with you, you need to focus on resolving the case. Get people talking and look for verbal cues. Carefully read body language for nonverbal cues. Make statements to see what reaction or lack of reaction is engendered. Figure out who are the leaders and followers in the room and whether there are differences of opinion in the group. Determine practical economic issues of the parties or the council, if there are any, and there usually are. So the disputants then get the opportunity to make an opening statement. That's a little formal, the word opening statement, but I think it's an apt way of describing it. Each party is invited to describe in his or her own words what the dispute is all about, how he or she has been affected by it, and to present some general ideas about resolving it. While one person is speaking, the other person is supposed to be listening. As I mentioned before, they're not always. Oftentimes they're it's called listening with the brain, with the motor running. They're listening, but they're also focusing on what they're going to say. That's where you as the media have that opportunity to paraphrase, summarize, etc. Take good notes. The party's opening statements can be very important, and having good notes are really, really a great benefit if the mediation goes on to different days. Now, with the work that I do, I carry a caseload of 10 to 40 cases at any given time. And perfectly honest, I have a pretty good memory, but it's not perfect. And I don't want to confuse issues between cases, and I don't want to confuse where somebody said, keep this confidential, and accidentally blurt it out. So taking notes can really benefit you and the parties. Don't skip the initial joint session and the opening statements. I've already mentioned that. Perhaps for the very first time, the parties are in the room together and are able to listen to what the other person says. If this has been going on for 2 years, their lawyers have probably or have likely indicated to them not to speak to the other party. Don't prejudice yourself by having a conversation. Let the lawyers do the work, which is fine. So this might be the first opportunity to actually hear what the other person has to say, and that can make all of the difference in the world. It gives them insights to the other person's process and perspective. And, when I do mediations, ahead of time, I'll hear one person's perspective, and then privately, I'll hear the other person's perspective. And at times, I wonder if they were in the same room when this conflict happened. The perspectives are so completely different. Neither are necessarily lying to me. They just saw it very, very differently. This is the point where you decide if you're going to have another joint session. You get to determine whether the status of the individuals, of the parties, their state of mind, whether you believe that they are prepared to have conversations, if they're being adversarial, if they have unchecked emotion, if they're able to engage in a joint session. This is determined, or you have to determine whether this is going to advance the resolution and settlement, or if it's just going to escalate the parties. If it's going to escalate, I would be doing shuttle mediation. They'd be in separate rooms, and I would be going back and forth. If I don't think it is going to escalate, and if I think that they are open to a collaborative conversation, that's where I will have the further joint session. So that's the next step, as I mentioned, the joint discussion. It can be either the easiest or the hardest stage for the mediator. Just because you've decided to go ahead and have the joint doesn't mean that you made the right decision. Sometimes it just it explodes, something happens, they hear something else, and they lose it. The easiest are situations when the mediator and lawyers have prepared the parties to have a frank conversation with the other party. The mediator only needs to interject for clarity, asking open questions, clarifying questions, maintaining control of the process, ensuring that all necessary information is put on the table, etc. The process, typically referred to as a joint session, has long been a staple for mediating litigated cases. However, there remain differing schools of thought on the efficacy of a joint session in a mediation. A joint session can spin out of control. Instead of advancing, it takes things backwards. So one has to be cognizant of what potentially could happen in a joint discussion before agreeing to do it. And ultimately, that is the mediator's decision. At the heart of every case is a story needing to be told. An effective joint session allows that story to be expressed in a safe way so that people can absorb the information. The peril of the joint session is that it denigrates into an adversarial exercise that pushes the parties even further apart. The caucuses is also a very important aspect. I recognize that we're running short on time, so I won't go through every aspect, but the way I do it in general is my first caucus with people, unless there's another reason, but my first planned caucus is information gathering. It's how it's done in joint session, or very similar to how it's done in joint session, but it's giving the people an opportunity to speak a little bit more in private, to express things that they don't necessarily want to express in the presence of the other party. You're also able to clarify information. You can check cultural differences. You can check all sorts of different factors that you might not want to bring up in a session when the other party is there. If you have questions, that really need clarification, sometimes when the other party is present, they're not as forthright. So that real advantages to having a private caucus for information gathering. My next one is what I call the disruption. That's when I find out what the BATNA and WATNA are. I talk to them about what their best alternative to negotiating agreement is. There are a lot of books on a BATNA and WATNA, so I won't go through it now, but a BATNA is the best alternative to a negotiated agreement, and a WATNA is the worst alternative. So it lets people do a bit of reality checking, having them say, if you don't resolve today, what's the best scenario for you? And when people start to think about that, they also start to think about potentially pushing some of their fears aside and getting closer to resolution. The reason for the private sessions are here. Overcoming resistance. It's a chance for each party to meet privately with the mediator to discuss the strengths and weaknesses of their position and consider new ideas for settlements. You're not in a court of law, so people can't come up with their own ideas on how they want to settle things. I'm not suggesting something illegal, but I'm suggesting that things that normally a judge might not rule on or might not decide for the parties. And people can be quite creative. Mediator can caucus with each side just once or several times as needed. Private mediators are considered the soul or the guts of a mediation. The caucus is also generally considered a part of the mediation process as private and confidential, what is said in the caucus remains between the parties in that room and is not shared with the other parties unless permission is given. I normally ask the parties to share as opposed to me sharing it for them. It's always best coming from the source, in my opinion. The duration, the timing of the caucuses, you have to decide how long, keeping them switching back and forth, who goes first, who goes second, how long you spend. I try to spend as close to as possible the same amount of time with each of the parties. If you spend 40 minutes with one and 10 minutes with the other, they're certainly going to wonder what in the world was going on in the first, and you don't want to let them think that there's a conflict of interest. And you also want to talk about the transition back to the joint session. Who's going to speak? What are they going to share? What issues do they wish to talk about? So just to expand on the caucus quickly, I use them when either I am or the parties are not comfortable exploring certain options. When times when people seem to be rushing to a premature commitment, when parties don't seem to be sharing in the mediation things that they've shared with me prior to it, when we want to talk about options and explore the options on each side, when mutual option sharing could reveal that a party wants to remain, things that they want to remain confidential, or when the mediator needs to clarify issues or explore statements made by either of the parties. Another very important aspect of a caucus is the emotional venting. If you'll recall at the very beginning, I mentioned that almost every mediation I've dealt with has had at its core some emotional factors. And because of that, people become emotional in a mediation. I've had people crying, I've had people yelling, banging the table, becoming angry. I look at them and their fists are so tight that their fingertips or their knuckles are red or white. Not that they're going to hit the other person. I haven't had that happen, thankfully, but that they're just so much stress and they're hearing things that they're not comfortable hearing. So if during the sessions, the mediation sessions, the joint session, people start to get overly emotional, sometimes it's a good time to take a break. Emotions have the potential to destroy a negotiation process, or when they are manipulative. When safety of another person is an issue, if somebody is threatening or seems to be threatening, let's take a break. Mediator can call a caucus specifically to give the disputing people the opportunity to release motions. Okay, let's go to the other room. Let's take 10 minutes. The person cries, the person yells, the person discusses with their lawyer, whatever it is that's needed. I believe it's very important to recognize any emotions that come up. If you're in a mediation and one of the parties is just crying, ignoring that is not going to help. I always have a box of Kleenex with me on the table. I always have a box of Kleenex with me on the table, and I will share that with the person. I'll ask them, "Do you need a minute? Would you like to take a break?" Sometimes they'll say, "No, it's okay. Give me a minute." Other times they want to take a break, and we can talk about it outside. I usually leave that decision to the party, as opposed to making that decision for them. Also, when people are a little scattered and they're not focusing, having a caucus with them can help them get that focus back and return them and have them focus on a settlement or an agreement before returning them to the final or to the mediation room. Now, mediation is not an isolated event. Just because things did not resolve on that day doesn't mean they won't resolve in the future. I think of mediation as really just the mediation itself is just part of the process. A dispute that's been festering for years can rarely be resolved in 8 to 10 hours. Take the time to lay the foundation for future settlement if it doesn't happen on that first day. Don't ignore the ethical considerations. Tell the party about all of these settlement offers from the other side. Unless things are different in Bangladesh, if one side offers a settlement, regardless of if it's the most ridiculous settlement you've ever heard of, you're there as the mediator, not to make decisions. So you need to present that settlement to the other side. This would be in a shuttle circumstance. Don't end the mediation abruptly and without warning. Once you decide it's just not going to happen today, never let or tell one side to leave without informing the other side. I have seen so many situations where one part is very clear it's not going to settle. People have remained positional. They're not budging. And so I say, okay, so it's now 11 o'clock at night. I don't see the advantages of going further, or 5 in the afternoon, whatever. I don't see the advantage of moving on. I'm going to go into the other room and let them know that we're going to stop now and then I'll come back, as opposed to just sending somebody home. I go to the next room. I explain to them the situation. Oftentimes that's when they, well, wait a minute. We do have another hour planned. How about if we make this offer? Or how about if we offer this? And they break through their position. Happens a lot. Follow up. Make sure that you follow up with people after the fact. It takes extra work, but the times when counsel or the parties are unreasonable, these are the opportunities for you to regain and to get some success after they've had time to think about it. Take calls in the evenings and on weekends and be available above and beyond. These are my recommendations. I speak to people, throughout the week. I have clients contact me, when I deal with Korea. For example, they are 7 hours ahead of me. So when I'm waking up in the morning, they're finishing their day. So that allows a very narrow time frame for me to be able to work with them. So I work various hours. I've attended meetings at 3 a.m. I don't want to do that. I don't like to do that, but the flexibility is something that I believe is important for us in our profession. As I believe I mentioned, there's 3 types of settlements: fully resolved, partially resolved, or not resolved. And these are the final circumstances for the day of the mediation. But it does not mean that it's over. When a settlement has been reached, the closing session will be used to confirm the terms of the agreement and ask the lawyers of the parties to draft a settlement agreement. The mediator should normally ensure that the parties do not leave the mediation until they have it signed and the agreement and all of the finer details are worked out. I have found that when people go home and they speak to other people that are involved, they come back with all sorts of different reasons and different conclusions, different settlement ideas, and it's almost like starting over again, depending on the type of mediation that you're doing. Often, though, only some of the issues will be resolved in a mediation, and a partially resolved mediation is also very appropriate. And they just need to be spelled out what those things are that were resolved. And the other issues can be dealt with later on or in other formats. In the situations where there's no settlement, where both parties are unable to reach a settlement, it may still be prudent to hold a joint session. This would be the case where the mediator is merely adjourned, where the mediation is merely adjourned for a day or two to a different date. And here the mediator can focus the parties on the process made during the day, and in the interim between sessions can speak with the lawyers and the parties to see about if there's any possibility of taking it to that next step of agreement. So, time, I have about 4 minutes. I'm not sure if I need to have questions in that. If I can just summarize what a mediator's role is. gathering the information, getting the facts, finding out what's going on, knowing as much information about the situation as possible. Active listening, active listening, active listening. I can't stress that enough. Get the story when the people are speaking. You'll get so many cues as to what they want just from their story itself. Encourage them to be collaborative, to use this mediation as a way of finding out a way of resolving things. Ask open-ended questions. When we ask closed questions, we get yes, no, yes or no, or one-word answers, and rarely do we find out much detail. Open up that same question. Tell me more about what happened on that day. I'd like to hear about your perspective on this. What are your priorities in this situation? What assumptions have you made in this conflict? What concerns you the most? What fears do you have? Which of your values have been impacted? All sorts of open questions that people can't answer with one word. That's where you get to really find out what's happening. The active listening, I mentioned, it's so important. A few more things I wanted to finish off on. Draw out the background context. When did you last have a conversation around this? What was your relationship like before this? That's a really, really great question. Two people had been working together or had been in business together or some sort of dealings in the past. It's a shifting technique. Oftentimes somebody will tell me, I worked with this person for 5 years and then a year ago this happened. So I'll ask them, so what about the 4 years before that? Tell me about that. And they usually have something good to say. So what will it take for you to get back to where you were before this happened, this occurred? Confirm. Let me just confirm what I understand. Tell me if I've got this right. Ways of getting people, of rephrasing what it is that you've heard. Be aware of nonverbal cues. Nonverbal cues can be misleading, but oftentimes they can tell you a lot as well. Somebody that's got their head down or that is very silent when they weren't, they may be contemplating or they may be something else. Ask the questions. When they've spoken to you, you're allowed to make a story out of that as well and feed that back to them to ensure that they know what it is that you've heard. And finally, a very final point is the value of silence. When I ask a question of a party and they don't answer me right away, I stop and I wait. I use the silence in the room to my benefit or to the benefit of the parties. I guarantee you that the parties feel a lot more uncomfortable than you do with the silence. If I were to jump in and ask another question, I'm letting the party kind of off the hook. They're given the opportunity to answer the easier of the two questions. So I stay there. I ask one question and I wait until they respond. And I wait. And this is, and usually what that means is you've asked a really good question. And if you look at it like that, you'll be able to move forward and help them from the answers that you receive from them. Are there any questions?
Thank you very much, sir, for such a stunning presentation and putting your heart and soul into your presentation. We really learned a lot.
I wonder, Kevin, if I might ask just one for you to answer to the query raised by one of our colleagues earlier, and that is, what happens, or what would you suggest to do if one of the parties to the mediation just simply doesn't appear at the mediation?
It doesn't appear. Well, first of all, in 30 years, that has never happened. But were it to happen, and I think probably the reason it hasn't happened is because of the work that's done before. all of the talking, all of the discussion, all of the questioning, all of the pre-mediation work, people show up because they're prepared to go ahead. In a situation where one of the parties doesn't show up, obviously the only thing I can do is cancel the mediation. I can't go forward with it with just one party there. I can spend a little bit of time talking to them about ways of how the mediation is going to happen, save some time later on. It's always possible that the person fell ill, had a car accident, whatever. I mean, I've been in Bangladesh, so having a car accident is an easy thing to happen with the traffic there. So anything could happen that could create that. I would hope that it wouldn't be because they've decided at the last minute, but I would have no choice. I can't think of anything else other than canceling the mediation or at least deferring it.
Thank you so much, sir. Respected participants, for your convenience, 2 files, mediation guidelines and circular are in the chat box. You can collect it from here. Mediation process can help us to lessen the loads of the cases. Here, mediator plays a very important role. Side by side, judges and advocates and others have their own role in this process too. At this stage of our program, we are really fortunate to have Honorable Justice Geeta Mittal ma'am among us. She was the Chief Justice of High Court of Jammu and Kashmir and recipient of Nari Shakti Puruskar from the President of India. Today, she will be describing the role of judges in promoting mediation. I would request Geeta Mittal ma'am to describe on this very important topic.
Thank you, Arundita. Can you hear me? Assalamu alaikum, salam.
Yes,
Justice
yes,
Iman Ali, Mr. S.N. Goswami, brother judges of the Judiciary of Bangladesh, learned mediators, members of the bar, participants, ladies and gentlemen. You have been having a very interesting morning and you have been taken through the important nuances of mediation. And I have been following and hearing. I heard Justice Iman Ali, who so, emphatically and so knowledgeably took you through the entire process of mediation, the legislation in Bangladesh, etc. So I have been asked to speak to you on the role of judges in promoting mediation. Having been a very, very strong protagonist of mediation throughout my judicial career, from the time I became a judge in 2004 till the date I retired, I deeply believed that mediation can really bring real justice to people. It enables parties to evolve a settlement. It enables people to decide an outcome of a dispute. The resolution is suggested by the parties, and it truly adds to peace in the community. I will take you briefly through, discuss very briefly as to where you find mediation in the traditional roles, in the, including in the religious texts, the guidance that we have received from the Prophet. And you will find indication of the process and its validation in your religion text as well. So, I will take you through a few slides. Then I will briefly discuss with you very, very briefly the role of the statutory provisions in how it can help you further mediation. Then what is the actual role of judges in the mediatory process? And finally, as to what are the benefits of the mediation. And I will also discuss with you the international instruments, which are recognizing and mediation, and what we need to do to become part of the international community of mediation, which is very, very important in the dispute resolution where international parties are involved, and also where you may have bilateral treaties between the state, that is the government of Bangladesh, and another private party, or two private parties and the government of another country. So how we can seek dispute resolution and how mediation can help us. So first of all, where do you find the reference to resolution, dispute resolution, that is Sulh in the Holy Quran? Now, this is what is said there, that the believers are but a single brotherhood. You can read the slide. So make peace and reconcile between your two contending brothers and fear Allah that you may receive mercy. Then the second portion, this is also an extract. These are extracts from the Holy Quran. I hope the translations are correct, where believers fall into a quarrel, make peace amongst them. Next, please. The ADR process in Islam includes, just like dispute resolution under civil law as recognized by statutes in Bangladesh and India, includes not only mediation as a method of dispute resolution, but arbitration, conciliation, etc. So you have Sulh, you have Tehkim, you have Medab, you have Muhtasib, you have informal justice by the Wali al-Mazlim, and you have the Fatwa. You have already seen, next please, quickly, just follow with me. Mediation related laws of Bangladesh. This you've already seen. Section 89A, which makes the mediation process mandatory. 89C, mediation in the appellate process. Then Atharin Adalatin Act, where after written statement you have mandatory mediation. The family court ordinance says the same thing. Then and the mediators are the courts themselves. Under the Village Court Act, you go to the Village Court, and then the Arbitration Act, which says that the parties can mediate and the resolution will be a consensus award. So we can skip these slides up to 13. We can skip it up. 14. This is comparable to section 89(15) of the Indian Code of Civil Procedure, which refers to makes mandatory a process of which provides the settlement. Next, please. Indian a settlement of disputes outside the court. It provides for arbitration, conciliation, judicial settlement through Lok Adalat or mediation. Now, what is the purpose of these statutory provisions? It is necessary to understand this if we have to evolve. What will be the role of us as judges in furthering the process of mediation? It is to advise parties. What can a judge do? Advise parties to choose the effective form of dispute termination or resolution. Should it be conciliation? Should it be arbitration? Should it be mediation? You will also have the role of educating parties about mediation. You also, because of your position as a judge, are placed very, very well to enhance the parties' willingness to negotiate and to deal with the resistance of parties regarding mediation. And significantly and most important, you will prevent the one party from misusing the process of mediation by maintaining overall control. Now, next, please. So, what will be the judicial attitude towards the mediation process? So, you are trained as a judge to decide disputes. So, you have an adjudicatory role. You decide. Two parties place their respective case before you, and you decide as to what should be the correct outcome thereof, keeping in view the applicable law. So you are bound within the four corners of the law that you will decide as per the law, and it is your view which prevails. What one or the other party wants is immaterial. So we are trained and we discharge this role day in and day out. This makes it very challenging for judges to appreciate mediation. So the first thing that has to be done to enhance our role in making a positive contribution to mediation is that judges have to be sensitized towards the purpose and need for mediation. You have to develop an understanding and have complete knowledge about the process of mediation. Mediation involves a mandatory 40-hour training, and increasingly this 3-day training, 2-day training is actually an initiation into the process of mediation, but it is not the 40-hour module, which is the module adopted all over the world before you can be called a trained mediator. This is only to introduce all of you to the process. So therefore, you have to develop a complete understanding and a complete knowledge, and you have to overcome your proclivity, your inclination towards the towards your adjudicatory role, and this requires a positive effort. A lot of judges feel that the mediation is a method of delaying adjudication or avoiding adjudication. So you have to actually learn to overcome that sense that mediation is not a method of avoiding adjudication as a judge or writing a judgment, but it is a significant process parties to have a resolved, a chosen outcome of the case rather than a judge imposed outcome. So, therefore, this is the importance of a training like this. It enables you sensitization. I heard some of you ask very pertinent questions of Justice Iman Ali, and it shows how engaged you were with the process. Now, when can you make a referral? Is every case, this is again very important, what will be your role as a judge? Is, can, even though your statute provides for mandatory mediation, but there is something called grooming. You have to groom a case, you have to groom the parties to make the process of mediation acceptable to them. You have to show them the benefits. I'll discuss the benefits and the pitfalls in a little while, but you have to understand the process yourself and guide the parties towards a willingness. So when can you make the referral? After you have ensured that the parties are willing for a settlement. Sometimes they may not be willing to settle, right at the outset, they're very discouraging. No, we don't want to go to mediation. So what will you do? You will bring them to a point, discuss with them the pitfalls of not going for a settlement, and bring them at least to a point where they're willing to look at a method of dispute resolution. Largely, this will happen when one person thinks he has a dishonored check from the other side, a check for 20 lakh rupees. He thinks his total entitlement is 20 lakhs. So you have to guide the party that yes, you may be entitled to 20 lakhs, but the other party may not be able to afford to pay 20 lakhs. Sometimes not able to pay in a lump sum. So you have to guide them that you'll be able to persuade the other party to pay in installments or lower the rate of interest or something. All this you can discuss in the mediation. You can't discuss in a court case where a case would be decided upon the evidence placed before you or on an admission by the other side. The check would be considered an admission. This is how you will use the opportunity of looking at when you're making a referral towards guiding the party towards the settlement. And most important, you yourself have to be satisfied that there is the possibility that there exist elements of a settlement. You cannot just a case come before you and come what may, send it for the mediation process without applying your mind. Next, please. Applying your mind to the matter. Now, what is mediation? A mediation is a voluntary, non-adjudicative form of a dispute resolution. It is voluntary because both parties accept it. It is non-adjudicative because you don't go to trial and the third party is not deciding. There is a neutral third party called a mediator, which Mr. Kevin Brown has just been emphasizing. A neutral third party assists the parties to do what? To reach an amicable solution through negotiation and facilitation. And they reach a solution which the parties themselves want. It is not a decision thrust upon them by third party, say a judge or an arbitrator. Even in an arbitration, a third party, an arbitrator decides. Then the process is absolutely confidential and impartial. This is very, very important. And who is a mediator? A mediator is a process expert and he is trained in communication and dialogue. He understands how to encourage dialogue. A lot of times, a contract or partners fall out, or in a matrimonial dispute, husband and wife are not willing to see each other. So the primary role of a mediator is brings them to a negotiating table and at this first sit against opposite each other, unwilling to look at each other even, let alone talk. And slowly the mediator helps break the ice, finds out what each one of them wants, either in each other's presence or in individual caucuses, as Justice Iman Ali and Mr. Kevin Brown have told you. And they break the ice. So even if a dispute is not resolved in mediation, the biggest advantage is people leave the mediation room, with more peace between them. At least if one of them says Assalamu alaikum salam, the other replies with a walaikum salam. Very, very important, This does not happen when a judge decides. One or the other party says, grave injustice done to me. So what are the other disadvantages of litigation? Poor judge population ratios in our jurisdictions, India, and I'm sure it's not much different in Bangladesh, makes it very difficult to get expeditious resolution of disputes. The litigation is so protracted, one or the other party is looking at delaying the case, and it's so heartbreaking for a party who's in a hurry in a matrimonial dispute where your wife is looking for maintenance, children custody battles, the other side who's got custody of the children or the person who has to pay the maintenance drags the litigation. So litigation is very protracted. And many times, most of the times, the costs of the litigation impede access to poor, women, disabled, and other marginalized communities. This is common in both our jurisdictions. So what can a judge do? Now, this is what you do. And this is what your questions before Justice Iman Ali were also. How do we persuade lawyers? Now, this is what you will do. You will talk to the lawyer and the parties together. Then you will talk to parties alone, and you enable bridging the communication barriers between parties. This is called grooming of the case before you send them to the mediator. You will tactfully convince. This is a very important role. And your role as a judge, your position as a judge, places you, you have a captive audience. Parties have to hear you. So a lot of time you'll have warring parties, who are a cantankerous lawyer, not willing to listen to you, but you can assert authority to make them listen, which even a mediator can't, You tactfully convince parties to attempt mediation, even in complicated, unconventional cases. And most importantly, you will address the credibility deficit. The lawyer says, who is a mediator? He's only a lawyer or a village elder or a family elder. You will address the credibility deficit, talk about experience of the other person, his impartiality and, no relationship to the dispute. And you will bring the parties to have faith in the mediator. This is your very, very important role. Then each one of you, or mostly district judges and the higher courts, constitutional courts, must ensure creation of necessary infrastructure. You must develop court annex mediation centers. In India, our experience has been that court annex mediation centers have the maximum credibility. And you have to provide quality mediators, facilitate. Now, you said, how do we break the barrier which lawyers are creating to creation of development of mediation? You will facilitate, creation of lawyer mediators. You will show them that this is another livelihood option. You will not only resolve disputes, but you can even earn money from mediation. We pay the mediators in Delhi and in India and in other areas in India. And you can also create such methods. And you must discuss. We have the same problem in the Delhi High Court, where the bar said, we will lose clients, our work will go down. But they saw for themselves that mediation does not take away the work of lawyers. And you can cite other examples, take the lead and instances of other jurisdictions and show, make the lawyers wiser. This is your very, very important role, that in ensuring that even lawyers and the bar looks at mediation positively. And you have to give publicity to the process and the benefits of the mediation. This was the last thing with Justice Iman Ali said. Now, publicity to the process and benefits of the mediation must be a takya kalam. It must be part of your daily routine. You must, and a judge talking positively of a process is the most credible thing. It's the most important role that you can play. It will give the largest acceptability to the process of the mediation and faith in the institution of mediation. And when we talk of developing quality mediators, what I must emphasize is that mediators do not have to be lawyers only. It can be a retired banker, it can be a chartered accountant, it can be an environmental expert, it can be an architect, it can be a retired bureaucrat. So get into training and do as much as you can to bring in mediators. Now, what you must also train, when you're training mediators is that they must possess patience and look for people who have a good sense of humor. This will take mediation a long way. Now, and then while you are taking mediation to the public, it is important that you sensitize the judiciary as well. You have to all judges also need to be sensitized towards the need and purpose of mediation. And you must ensure that the judge develops the attitude which is favorable towards usage of the ADR. What can you do to increase the mediation, promote mediation? Refer as many cases as you can to the mediator as far as possible. Your adjudicatory role, as I've said, makes it difficult for you to objectively determine the settlement or possibility of a settlement. You must train yourself. You must take your bias against mediation and non-adjudicatory methods of dispute resolution and look at it positively. Look at mediation positively. Remove your own biases, shed your own prejudices that you have, and ensure that more and more cases are groomed and parties are groomed and sent to mediation. So, what can a judge do to mold the party's perception and willingness? So, how do you build confidence in the party? You must have a brief interaction before you send them for settlement through mediation. You should highlight the process and benefits of mediation. You must tell them parties, they will be more willing to go to the mediator if you tell them that the process is absolutely confidential and you create confidence and faith in the parties of mediation. So you yourself have to believe it before you send them to the mediation stage. And you must also ascertain whether previous attempts have been made for settlement. You don't have to stop at making only one attempt for the mediation settlement. You can send a case which comes back unresolved after mediation to you. You must talk. You can talk to the parties if they agree. You can send it again and again. And each time some of the disputes will come back, even if the full case doesn't get settled, but partial settlement, you'll see some issues get resolved. You have to believe in it, and you have to place mediation on an equal pedestal as litigation. There are several, because of you must tell the parties of the benefits of the mediation, that the settlement is reached without compromising on impartiality or the confidential nature of the information which they share with the mediator. So, what I've said, grooming, preparing parties is the most important thing that you must do before you send a case. Even where you have no choice about the stage at which you can send, your acts tell you after written statement, etc. We have experienced that a lot of times, especially in matrimonial cases, the moment a written statement comes, parties harden position. So you can ask the filing of the written statement in sealed cover. and then without letting the other party see the defense, so that they don't harden their positions, attempt a mediation settlement. So you must place mediation on an equal pedestal as litigation, and only then will parties have faith in the process. It is a process which can be placed at a equal place, and then they will look at mediation more positively. There have been several instances, I'll come to that later, where even after the parties weren't able to settle during the trial, at appellate stages, people have been persuaded to go to mediation and resolve multiple disputes. So, there are several studies which show that referral judges, play a seminal role in advancing mediation. Next, please. I must point this out to you, that there is a huge vacuum in legislation. I've seen that in your statutes. It's the same experience in India, which must be addressed. Perhaps judgments of the court or the Supreme Court or the higher courts may be able to help you. I understand that the Supreme Court in Bangladesh has issued some guidelines on mediation. I've not had a chance to examine, but there is a vacuum on the process of mediation. You must note that there is no standardized training module and format for it. Then we have no norms for standards and ethics of evaluating mediators. These must be prescribed. Just like, you have standards and ethics, and, for lawyers, you have ethics. For judges, you have the Bangalore principles which guide judges' conduct. But we do not have such standards and ethics for mediators so far. There is no process of accreditation of mediators in Bangladesh as well. This is very, very important. You have district judges recommending, or legal aid people being called mediators. This is not sufficient. You must have a standard, a format. What must be the qualification? What must be the age? Then also, mediation is not permissible in criminal and quasi-criminal matters and in other laws, other than the few cases provided by law which are compoundable. In India, I have not checked up Bangladesh, it is section 320 of the Code of Criminal Procedure. You must be having a similar equivalent provision in your criminal procedure code which permits compounding in some cases. But there are other matters, where are new laws which have come in, which are quasi-criminal. For instance, section 138 of the Negotiable Instruments Act, in India, check bouncing, it's a summary procedure, but these are cases which are compoundable. So, there's no prescription by law, and law must consider this vacuum and provide mediation in disputes under special statutes. Disputes of directors in Companies Act, there's no prescribed procedure. Then also mediation in cross cases. We don't know how to evolve that by statutory guidance, and also mediation before other forums, say tribunals, and recording of settlements, company law board of settlement, where is to go. Then method of enforcement, next, enforcement and execution of the mediation settlement. This must be statutorily prescribed. I've had, these came up as major disputes in courts, and that's where I realized the vacuum. Then what must you do? I have already said so. All that you must do. We'll go to the next slide. Do's for referral judges. You must ensure, this is again your role in promoting mediation, you must ensure the presence of the parties before the referral. You must assess the relevant facts of the case, interact with litigants at the time of referral, ascertain willingness, obtain free consent, also find out reasons if parties are not willing for mediation and address these reasons. If no consent, please ascertain other areas where there are elements. Next, please. You will explain benefits. I'm summarizing now on what I've already said, and make an appropriate referral order. brief referral order, obtain signatures of parties on the referral order, fix the date and time of appearance before the mediator, fix the schedule of the trial, explain the role of the mediator, explain the right to self-determination and confidentiality. You will ensure who will appear before the mediator. Only parties or authorized representatives should appear. Now, you have no choice. Most of your statutes make it mandatory, but in statutes where mediation is not prescribed, this is what you must do. Select the cases depending on characteristics. Again, encourage advocates and litigants for mediation. And also, if there is a government agency or authority involved, ensure their appearance of an authorized person before the order. Referral order. Referral of the case done by referral order. Referral order sets the tone for mediation. It should not be passed casually. Should contain sufficient details about mediation process. Then all categories are not suitable. Referral judge should identify categories. Next. You must give a little background of the case before you send the case in the referral order. Fix the date and time of appearance. Provide definite time limit for the mediation. Now, which are the disputes most appropriate for mediation? In cases where beyond the not governed by section 89A or the Arthadeen or the other enactments, but please ensure that none of the defendants are ex parte, that the parties desire a negotiated outcome, the parties want to maintain a future relationship, the litigant does not want to appear as a witness. These are cases, parties want to maintain a future relationship, two partners, two brothers, father and a son, daughter and a father, daughter and a mother. These are cases where they'll want to resolve mutually. Then if a plaintiff or a defendant doesn't want to go through cross-examination, he'll be very willing to resolve the dispute through mediation. Mediation should not, and then you must, when they're conscious that cost as well as time of the trial exceeds the projected value of mediation. And mediation should not be permitted to be used as a tool for delay. You must also ensure that reference to mediation is not being taken only as a tool for delaying. Then I have enumerated cases which are very suitable, matrimonial cases, accident cases, insurance, property disputes as injunction, community disputes, intellectual property cases, criminal compoundable cases, etc. Next, please. Then cases arising from trade, commerce and contracts, money suits, specific performance, landlord-tenant, insurer and insured. These are all amenable to mediation. Next. Cases which arise from strained or soured relationships are also very amenable, Partition of property between family members, matrimonial causes, partnership disputes. Then I've pointed out pre-existing relationships you want to continue. Disputes between neighbors, even if the case is not settled, you have to continue to live together. So employer-employee relationships, society associations, the people are very willing to settle. Tortious liabilities are amenable. Motor accident claims. Then where disputes not parties which are case not appropriate for mediation, where parties refuse to negotiate and want a judicial determination, where a judgment may contribute to development of law, or the case may involve disclosure of sensitive information, or there are multiple parties and issues, parties do not have sufficient information, then interpretation of the constitutional provisions, statutory laws, then cases where the government is a party will not be amenable to mediation, and cases barred by statutory mediation. Then if you want to promote mediation as a judge, please remember that you have to keep communication with the mediator to a minimal. No remarks should be made blaming either party, and no communication should be made on the merits. On receipt of a settlement, you must ensure that the settlement was voluntary, that the settlement is not collusive or illegal, and the settlement is workable. You can modify or amend the terms of the settlement with the consent of parties to overcome any technical or procedural difficulties in implementing the settlement and pass a decree. I think I've almost run out of time. In case there is no settlement, just run over these slides. You will continue in accordance with law. Now, I'll just briefly touch on international commercial disputes. This is what Lee Hsien Loong, Prime Minister of Singapore, has talked about disputes. About now more there is, with the internet and communication being so easy that the entire world has become our platform, and we find that disputes disrupt normal business operations. They damage reputations, hurt share prices, make it harder for companies to raise capitals, dampen the confidence and morale of employees, shareholders, and other stakeholders. A robust framework to manage such conflicts can prevent such disputes from escalating or unnecessarily or causing unintended consequences. Now, this is of special problem where international commercial interests are involved, and they can even hurt the economy of the country. Now, mediation is a very, very expeditious tool. And what are the obstacles in commercial mediation at an international level? First of all, it will be very difficult because we have not created the framework for for working with the working and ensuring execution of mediated settlement terms. So the first difficulty is how to ensure both parties comply with mediation settlement terms. Then countries have lack of legislative framework making these settlements enforceable in courts, unlike judgments and arbitral awards. A mediation settlement between, say, a company in Bangladesh and a company in Australia occurs before the Singapore International Mediation Center. How will the company in Bangladesh enforce it in the courts in Bangladesh? Then lack of an efficient and harmonized framework for cross-border enforcement. So conscious of this, the UNCITRAL's working group 2, framed a convention. This was adopted by the UN General Assembly on 20th December 2018. And next, it was opened for signature on 7th August 2019 in Singapore. It is commonly known as the Singapore Convention on Mediation. It was signed by 53 countries and ratified by 6 countries. It has been signed till date. From amongst the SAARC countries, which includes Bangladesh, only Afghanistan, India, Maldives, and Sri Lanka have signed the convention. Pakistan, Nepal, Bangladesh have yet to endorse this. So the convention entered into force on 12th September 2020. The key features of the convention, this is very important, and pardon me, the organizers will pardon me for taking 2 minutes extra. The key features of this convention is that they are applicable to international commercial settlement agreements which result from mediation. So they enable courts of a contracting state party which is entrusted with the task of enforcing such a settlement agreement, and they allow the party to invoke a settlement agreement to prove that the matter has already been resolved in accordance with the rules of the procedure. So you have to not only sign and ratify the convention, but create a domestic law. Next, please. Create a domestic law to enforce this convention, which is very essential. In India, we haven't created the domestic law. So, I would request the authorities in Bangladesh to also look into this aspect and provide for this, Then courts are enabled to, since this is not applicable to Bangladesh, I will refrain. And I'm out of time. Let's go to the benefits of the convention. This has included 52. So this has become a very popular tool for resolving cross-border commercial disputes, and it reduces instances of disputes which leads to termination of contractual relationship. It has enabled administration of international transactions by commercial parties by local courts. It saves in the administration of justice by the states, So much time would be spent in serving, say, a party in Australia by the court in Bangladesh. If you could have a mediation settlement before a jointly agreed mediation body enforceable in Bangladesh. Mediation complements both litigation and arbitration. So this must be addressed. I am told that the BIT, normally have a cool-off period. That is bilateral international treaties which provide a cool-off period before people can take to dispute resolution methods of litigation, arbitration, etc. This cool-off period provided in the agreements can be used for diverting the parties to explore the dispute resolution process by mediation. So, Nick, let's go next. So this is, very, very important, and it will facilitate development of mediation. I'd just like to share two instances where I was able to use mediation very, very successfully. In a matter, there was a criminal appeal where by a party challenging his conviction for murder of his brother-in-law using contract killers. The complainant, person murdered, the victim was this person's brother-in-law, sister's husband. And the sister had said that the motive for the murder was property left by their father. So, though the murder appeal is not negotiable, it cannot be mediated. However, there were the property disputes in which the parties were in civil litigation before the court, before the High Court of Delhi, was referred to mediation in the murder appeals, and the parties were able to resolve the civil disputes. I had directed that the dispute resolution, the mediation settlement, be placed for settlement in the suits. And, so therefore, even in difficult cases where by law you cannot, which are not are not negotiable by and resolution by mediation is not possible, but the underlying disputes can be sent for mediation, and the mediation settlement can be enforced. In another matrimonial case, where one of the wife had appealed against a simple maintenance order, given by the trial court, a very deficient maintenance order. So I had, during my discussion and interaction with the parties, I found that they had filed 28 cases against each other. And they had reached middle age. They were in the middle 40s by the time this case had come before me. I was able to discuss with the parties and persuade them to attempt mediation. And they were able to enter into a negotiated settlement. And by this small act of persuading parties, sending them to negotiate, for 28 cases before different courts, not only in Delhi, but in Amritsar and in other cities in India, had got resolved. So you have a very, very important role in encouraging and developing mediation. I've already said what all you can do: creation of court annex mediation, addressing credibility deficit, etc. But most important, as Justice Iman Ali said, that apart from engaging with other parties, reducing the credibility deficit and facilitating development of quality mediators, preparing norms, laying down process for accreditation, publicity to the process as well as benefits of mediation is something that judges can do a lot. This must be done through enhanced and effective data dissemination. Use your legal services authorities for spreading the message of mediation, high and low, wide and far in Bangladesh. You must emphasize that mediators do not have to be lawyers. Involve bureaucracy, involve chartered accountants, architects, other domain experts. Train them, get them trained after first prescribing a 40-hour module. And you must spend more time with the bar. address the lawyers and the bar, involve them in the training, call senior lawyers to train in training programs. We have a very robust mediation program in the Delhi High Court where we have put members of the bar, the president of the bar, as member of the mediation committee. And we involve them in all our rule making, etc. Rules are made by us, by the full court, but they get a chance, they get a platform to give, so to guide us. So you must look at legislation also at settlements at the pre-litigation stage. Very, very important. There is a huge legislative vacuum in India. They're trying to address it in some of the statutes. It has been done, but Code of Civil Procedure has not done it. And what if the party court sends the parties to a mediation in a legislation where mediation is not provided? Say somebody approaches the court for appointment of an arbitrator, and the parties are sent to agree to go to mediation of the larger dispute. The dispute is resolved. Where will this settlement be placed? In which litigation? The litigation gets over the moment the parties are sent to the mediation. So lastly, I'll just like to remind you people of a few instances where the Prophet Muhammad mediated very successfully, and this should inspire parties. The mediated settlements, he mediated in human problems, between problems between groups. So you're all aware of the reconstruction of the Kaaba, the building in Mecca to which Muslims go for a pilgrimage, and a dispute had arisen over placing of the black stone, the Hajar al-Aswad, into the building. All the 4 tribes of the Quraysh wanted to have the honor of placing the stone to the exclusion of the others. An impasse had arisen and the matter was referred to the Prophet. He resolved it so simply. He asked each of the contesting tribes to choose a leader. He then spread a full sheet of cloth on the floor and placed the stone in its center and asked all the leaders, the 4 leaders, to each hold one corner and raise it together. Thus, the serious conflict was averted by the Prophet's such a wise action in giving all 4 leaders equal honor of placing the stone. This could not have happened in a court of law. It can only happen in a mediation. Then during his time in Medina, it is a report where the Prophet successfully mediated a dispute between a creditor and a debtor. He suggested that the creditor half the money owed to him if the debtor immediately paid in full. But if
Recording
he wanted to
stopped.
pay in installments, then the full money would be payable. I think I've run out of time. Is that right, Arundhita?
Yes, ma'am.
So I should stop now. You must.
And you can continue if you need.
Okay, just 2 more instances. I know these are interesting stories and they're true instances which the participants may like to hear. There's also an implementation of a sulh, in the case of the making of the Treaty of Hudaybiyah, where this is narrated by Al-Bara bin Azid, that when the Prophet made the peace treaty with the people of Hudaybiyah, Ali bin Abi Talib wrote on the document,
Recording in progress.
The Muhammad, Allah's apostle. The pagans said that it should not be written, because if it is an apostle, they could not fight with him. It was the Prophet who asked Ali to obliterate the same, but Ali refused to do so. And the Prophet himself, you can remove the slide, himself erased it and made peace. Then the Medina Constitution, which was enacted by the Prophet, includes a provision where, based on ijma, the consensus of opinion, the Prophet has said, I quote, conciliation between Muslims is permissible except for a conciliation that makes lawful unlawful and unlawful lawful, unquote. The Prophet also recommends and guides, and I quote, intercede so you will be rewarded, unquote. So these are a few instances of where the Prophet has himself encouraged the process of mediation. So with the efforts of Justice Iman Ali and the wonderful organizers, excellent training, and all of you judges getting trained, I'm sure mediation in Bangladesh is going to grow leaps and bounds. And very grateful to the organizers for giving me this opportunity of, sharing your journey and sharing some of my experiences in the mediation. I have used mediation extensively in court, and I've tried to encourage it. It was almost a non-starter when I took over as Chief Justice in Jammu and Kashmir. And the first step to encouraging mediation is to sensitizing judges and ensuring that they believe in the process. So I hope all of you, with the efforts of the organizers, will have faith in the process of mediation, look at sensitizing yourself further, and ensuring that the people of Bangladesh, especially its lawyers, they believe in the system as much as you do, and mediation takes off in a very, very large way. Namaskar.
Thanks a bunch, ma'am, for an incredibly thought-provoking and inspiring discussion. We are deeply grateful to you. Ladies and gentlemen, this is the question and answer session, and you are requested to ask if you have any doubt, query regarding any matter related and not related to the subject matter. You can raise your hand if anyone wants to ask any question.
It looks like everybody is hungry and ready for lunch. Any quick questions? Please be brief in your question.
Sir,
Just unmute your mic and please pose your question.
Hello, am I audible?
yes.
Yes,
You are audible.
Yes, this is Srijani Tripura. আসলে সকাল থেকে ট্রেনিং সেশনটা শুনছি হচ্ছে যে আজকে আমাদের এখানে অনারেবল জাস্টিসরা আছেন, জাজেসরা আছেন, তাদের সকলের মাধ্যমে আমি শুধু এই একটা রিকোয়েস্ট করতে চাই আমাদের কমিউনিটি মেডিয়েশন সেন্টার থেকে যে আমাদের কিন্তু অনেক সময় কোর্টে দেখা যায় যে হচ্ছে যে লয়াররাও অনেক সময় অনেক কিছু সলভ করতে পারে না, ইভেন 10 ইয়ার্সেও একটা জিনিস সলভ হয় না, সেটা যদি জাজেসদের মাধ্যমে বা জাস্টিসদের মাধ্যমে পিপলদের কাছে মেসেজ যায়, ডিসপুটেড পার্টিসের কাছে মেসেজ যায়, তারা কিন্তু অনেক রেসপেক্ট করে ম্যাটারটা। আমরা কোর্টের এক্সপেরিয়েন্স থেকে দেখি বা আমাদের রিয়েল লাইফের এক্সপেরিয়েন্স থেকে দেখি যে জাজ সাহেবরা বলেছেন আমাদের একটু কনসিডার করার বিষয় ব্যাপারটা, এটা কিন্তু আমরা রিয়েল এক্সপেরিয়েন্স থেকে দেখি, আমরা যারা অ্যাডভোকেট হিসেবে কাজ করি তারা। তো আমি আজকের এই প্ল্যাটফর্মের মাধ্যমে আমাদের যারা অনারেবল জাস্টিস আছেন এবং হচ্ছে যে যারা জাজ সাহেবরা এখানে এসেছেন তাদের সবাইকে একটা রিকোয়েস্ট করতে চাই, সেটা হচ্ছে যে তাদের মাধ্যমে যদি মেসেজটা যায়, আমি মনে করি যে বাংলাদেশের মানুষ সচেতন হবে এবং আমরা যে আমাদের যে ক্রাউড অফ কেসেস থেকে আমরা সহজেই কিছুটা মুক্তি পেতে পারি অন্তত। ধন্যবাদ সবাইকে।
জি, আসসালামু আলাইকুম। আমি সিরাজউদ্দিন, সিনিয়র সহকারী জজ, চাঁদপুর। আমি একটু বিষয় শেয়ার করতে চাচ্ছিলাম।
Yes, of course.
আমি আজকের আমাদের অনুষ্ঠানের সম্মানীয় অতিথি জনাব ইমান আলী স্যারের কাছে আমার একটা বিষয় আমি বলতে চাচ্ছিলাম স্যার। সেটা হচ্ছে স্যার আমার 8 বছরের মানে জুডিশিয়াল সার্ভিসের যে অভিজ্ঞতা, সেখান থেকে আমি দেখেছি যে একটা মামলা প্লেন্ট এবং রিটেন স্টেটমেন্ট হওয়ার পরে যখন আমরা এডিআর জন্য সেটা কল করি বা আমরা যখন বসার চেষ্টা করি, সেক্ষেত্রে বেশিরভাগ সময় আমি আমার এই স্বল্প সময় অভিজ্ঞতায় দেখতে পেয়েছি যে বিপক্ষের এঙ্গেজ লয়ার তারা মোস্ট অফ দ্য কেসেস তারা নেগেটিভ রোল প্লে করেন, মানে অর্থাৎ তারা চান না যে মামলাটা মেডিয়েশনের মাধ্যমে বা বিজ্ঞ বিচারকের মাধ্যমে নিষ্পত্তি হোক। তারা যদি স্যার হ্যালো
Yes, you are audible.
Yes, please you continue.
জি, থ্যাংক ইউ স্যার। স্যার এখন আমার বিষয়টা আমি যেটা বলতে চাচ্ছি যে বিজ্ঞ লয়াররা দুই পক্ষের অ্যাঙ্গেল যারা লয়ার থাকেন অ্যাঙ্গেজ তারা বেশিরভাগ ক্ষেত্রে আমার অভিজ্ঞতা বলে তারা নেগেটিভ রোল প্লে করেন, কারণ মামলাটা যদি ইনিশিয়াল স্টেজে শেষ হয়ে যায় সেক্ষেত্রে তারা একটা মামলা থেকে যে বেনিফিট পাওয়ার সুযোগ ছিল তাদের সেটা নষ্ট হয়, এবং তারা এই নেগেটিভ রোল প্লে করার কারণেই বা তারা দুই পক্ষকে বোঝানোর কারণে যে মামলাটা যদি তুমি তোমার এখানে ভালো ইন্টারেস্ট আছে বা ভালো সুযোগ আছে তুমি এখানে উইন করতে পারো, তারা এটা যখন উভয় পক্ষকে তারা কনভিন্স করার চেষ্টা করে এবং তারা নেগেটিভ রোল প্লে করার কারণে আমরা বেশিরভাগ ক্ষেত্রেই আমরা যে এরিয়া গুলো করার চেষ্টা করি আজ বিচারক জাজ আমরা ফেল করি। মনে হয় যে এডিআর স্টেজে বিজ্ঞ বিচারক উভয়পক্ষের লয়ারদেরকে নিয়ে বা পক্ষদেরকে নিয়ে যেমন আমরা বসি এবং সেখানে যদি এডিআরটা সাকসেসফুল হয় সেই ক্ষেত্রে যদি উভয়পক্ষের লয়ারদেরকে উভয়পক্ষের লয়ারদেরকে আদালতের মাধ্যমে বা কোর্টের ইন্টারভেনশনের মাধ্যমে বা বিচারকের হস্তক্ষেপের মাধ্যমে যদি এখানে একটা রেনুমারেশন বা একটা সম্মানিত ব্যবস্থা করা যায়, আমার কাছে মনে হয় তাহলে সেক্ষেত্রে বিজ্ঞ লয়াররা হয়তো এই মামলাগুলোকে বিচারকের মাধ্যমে এডিআরে করতে বা রিজলভ করতে তারা অনেক বেশি আগ্রহী হবে, এবং তাদের এই অনাগ্রহে আমার কাছে মনে হয় এই মামলাগুলো নিষ্পত্তি করার ক্ষেত্রে একটা বড় ধরনের বাধা হয়ে কাজ করে। যদি এটা তাদের একটা সম্মানী দেওয়া যায়, এটা যদি সফল হয়, তারা যদি একটা ভালো সম্মানী পায়, আমার ক্ষুদ্র জ্ঞানে মনে হয় যে তারা তখন এই মামলাগুলোকে এডিআর স্টেজে নিষ্পত্তি করার ক্ষেত্রে অগ্রণী ভূমিকা পালন করবে এবং এটা আমাদেরকে অনেক বেশি হেল্প করতে পারে। স্যার ধন্যবাদ। স্যার
আমি কি একটু বলবো?
ইয়েস স্যার।
প্রবলেমটা তো আমরা সবাই স্বীকার করতেছি যে এইখানেই লয়াররা তারা এনকারেজ ফিল করেন না, মনে করেন যে আমার মামলা তো চলে গেল। তো এইখানেই আমাদের সবার একটা অ্যাওয়ারনেস এর ব্যাপার আছে। হ্যাঁ, আপনি ইউ আর কোয়াইট রাইট। যদি লয়াররা মনে করে যে কোনো ফি পেলাম না, মামলা শেষ হয়ে গেল, তাইলে দরকার কি, মক্কেলকে সরাই নিয়েই ভালো। দ্যাট ইজ এক্স্যাক্টলি হোয়াট ইজ হ্যাপেনিং। তো এই ক্ষেত্রে আইনের মধ্যে কোথাও নাই যে আমরা লয়ারদের একটা সম্মানী দেব। তবে এটা আমরা বলতে পারি, আপনারা যখন পার্টিকে বা লয়ারদেরকে অ্যাডভাইস করবেন ওই গাইডলাইনের আদলে, তখন আপনি বলবেন যে হ্যাঁ, যদি বিশেষ করে যদি আপনার লিগ্যাল এইড কোয়ালিফাই করে তাহলে লয়ারের ফিটা লিগ্যাল এইড থেকে দেওয়া যাবে। ফি কত আমি জানি না, লিগ্যাল এইড কত দিতে পারবে তাও আমি জানি না। তবে ইউ কোয়াইট রাইট, আমার মনে হয় একটা যদি ফিক্সড অ্যামাউন্ট নির্ধারণ করা যায় দ্যাট উড বি বেস্ট। কিন্তু এটা কিভাবে করা যায় আমি আপনাদের কাছ থেকে সাজেশন নিতে চাই। বলেন আপনারা কিভাবে আমরা অগ্রসর হইতে পারি এদিকে।
Sir, another participant raised her hand. Moiti Bhattacharya, DLAO, Coxbazar.
Thank you for giving me the floor. Can you hear me?
Yes. Yes.
Sure.
Thank you. And I want to share an experience of an interesting case. While I was working as an assistant judge in Kumilla, I found a case where 4 sisters filed a case for partition, claiming their portion in their father's property against their sole brother. So I adjourned the hearing and I put it for mediation. According to section 89A of Code of the Civil Procedure, I initiated the mediation process. I discussed with the parties, and it was revealed in the discussion that that brother had created some forged document showing that those sisters had already sold their portion to their brother. He himself admitted that those documents were forged in nature. But unfortunately, that mediation process was not succeeded. But as a judge, I came to know the truth that those documents were forged. But in the litigation process, the irony of the fate is that in the litigation process, because of the inefficiency of the lawyer of the other party, those documents were not challenged as forged documents. And we know that the mediation process is confidential in nature. So the judge can't make a decision which he came to know in the mediation process. So I think while I am acting as a mediator and as a judge, while I I am giving a decision, I felt helpless. I could not do anything. I came to know the truth, but because of the ineffective steps taken by the other party, I can't make a good decision. I could not do the justice for the four sisters. So I want a suggestion from our honorable sir, honorable justice sir, and other trainers that in such a case, what a judge have to do.
Well,
I felt myself helpless in that case.
So first things first, if you sat as a mediator in the case, then you could not sit as a judge again in that case. You should not have sat as a judge, because then the law says that the person who has done the mediation cannot sit as a judge. He has to send it to for another judge to be appointed to hear the case in litigation. Number one. Number two, if that had happened, and if the case was then dealt with by another judge, and even if the lawyer has, it is up to the judge to conduct his own court. If he feels that the documents are forged, even then he can suo motu ask for the documents to be, because he can do anything that he feels is necessary in order to do justice in the case. But if he doesn't know that they're forged, if he accepts that they are genuine, well, too bad. The lawyer of the other side, lawyer of the girls, is to blame. But maybe they will come to it at some point. Maybe at some stage they will, either at appeal or somewhere, they will decide that they will have the documents verified and attested.
Thank you, sir.
Sir, another participant raised her hand, Farhana Lukman.
Assalamu alaikum. Am I audible?
Yes, you are audible.
Yes. Thank you. Assalamu alaikum, Honorable Justice Sir, and all the participants. আমি ফারহানা লোকমান, আমি জেলা লিগ্যাল এড অফিসার হিসেবে প্রায় দীর্ঘ 4 বছরের মতো। স্যার, আমি এই এক্সপেরিয়েন্স থেকে আমি কিছু শেয়ার করতে চাই আর কিছু প্রশ্ন রাখতে চাই। সেটা হচ্ছে স্যার, লিগ্যাল এড অফিস প্রিকেস 2 ধরনের মিডিয়েশন আমরা করে থাকি। একটি হচ্ছে প্রিকেস মিডিয়েশন, আরেকটি হচ্ছে পোস্ট কেস মিডিয়েশন। তো প্রিকেস মিডিয়েশনের সংখ্যায় আমাদের এখানে সবচেয়ে বেশি হয়। যেমন প্রিকেস মিডিয়েশন গত বছর কুমিল্লাতে আমি 455টি প্রায় প্রিকেস মিডিয়েশনে বসেছি। এর মধ্যে প্রায় 63টির মতো কাছাকাছি সফল হয়েছে, এবং এর মাধ্যমে কুমিল্লাতে শুধু প্রায় 1,12,00,000 টাকার মতো আদায় হয়েছে, এবং সারা বাংলাদেশে কিন্তু এখনো পর্যন্ত প্রায় 59 কোটি টাকার মতো আদায় হয়েছে। স্যার, এখন আমার প্রশ্ন হচ্ছে স্যার, এই যে প্রিকেস যে মেডিয়েশন আমরা করছি, এর মধ্যে দেওয়ানি অনেকগুলো প্রবলেম থাকে। একটা মেডিয়েশন আমি একটু শেয়ার করতে যাচ্ছি, যে একজন নারী আমার কাছে এসেছেন, তার 100 জায়গা আরেকজন বেদখল করে রেখেছেন। আমি প্রায় 6 মাস ধরে চেষ্টা করে 2 পক্ষের মধ্যে আপোষ করে একটা আপোষ আনতে সক্ষম হয়েছে, যে অপর পক্ষ তার জায়গাটি, মহিলাটির জায়গা মহিলাকে ফেরত দিয়ে দিবে। কিন্তু যখনই আপোষ চুক্তিও হয়েছে, স্বাক্ষরও করেছেন, কিন্তু যখনই মাঠে যান পক্ষের ছেলেরা আর তাকে, সেই মহিলাকে কোনোভাবেই সেই জায়গাটি দখল করতে দেয়নি, এবং এই মহিলার কাছে এই খাস দখলের মামলা করার মতো পর্যাপ্ত অর্থও নেই। লিগ্যালের থেকে আমি তাকে সে অর্থ দিতে পারছি না, কারণ এটা অ্যাডভেলোরাম কোর্ট ফি, অ্যাডভেলোরাম কোর্ট ফি লিগ্যালের থেকে দেওয়ার সুযোগ নেই। তো এই যে আমার প্রচেষ্টা এবং হচ্ছে এই মহিলার যে অধিকার, এটা কিন্তু আমি রক্ষা করতে পারলাম না। কিন্তু আমি যে পরিশ্রমটা করেছি বা তার যে অধিকারটা এস্টাবলিশ হয়েছে, অপরপক্ষ স্বীকারও করেছে, সেটা শুধুমাত্র উইটনেস, এটা মানে সাক্ষ্য হিসেবে উপস্থাপন করা যাবে, কিন্তু সেই জন্য তো মামলাটা করা দরকার, সেটাও করা যাচ্ছে না। এই ক্ষেত্রে স্যার আমি বলতে চাচ্ছি, এই যে প্রিকেস আমরা যে বিচারক হিসেবে করছি, সিনিয়র সহকারী জজ, এবং এটাকে কোনোভাবে এনফোর্সেবল করা যায় কিনা। তাহলে যদি এনফোর্সেবল করা যায়, তাহলে কিন্তু এই যে আমি 1 কোটির কথা বলছি বা 56 কোটির কথা বলছি, এগুলো কিন্তু অনেক বেশি বেড়ে যাবে। এবং হচ্ছে মানুষ অনেক বেশি সেবাটা পাবে এবং আমাদের উপর রিলাইও করবে। এখন কিন্তু যেটা হয়, যখন দেখছে যে আপোষ না মানার ফলে তাদের কিছু হচ্ছে না, তারা কিন্তু রিলাক্টেন্ট হয়ে যায়, তারা গ্রামে বলে যে এখানে কিছু হয় না, এরকম একটা ব্যাপার। আরেকটা বিষয় স্যার, সেটা হচ্ছে ক্রিমিনাল মামলার ক্ষেত্রে। স্যার ক্রিমিনাল কেস অনেকগুলো অপরাধী কিন্তু কম্পাউন্ডেবল, এবং নারী শিশু কোর্ট কেসও রিসেন্টলি আমাদের অনারেবল হাইকোর্ট থেকে বলা হয়েছে কম্পাউন্ড করা যাবে। কিন্তু এই মামলাগুলো কিন্তু আমাদের লিগ্যাল এইড অফিসার কাছে রেফার করার কোনো সুযোগ সিআরপিসিতে বা সংশ্লিষ্ট আইনে নেই। এই কারণে এই মামলাগুলো লিগ্যাল এইড অফিসে আসতে পারে না। তো এই মামলাগুলো, এই পেটি অফেন্স এবং কম্পাউন্ডেবল কেসের মামলাগুলো যদি লিগ্যাল এইড অফিসে রেফারেন্স ব্যবস্থা করা যেত, আমার মনে হয় যে মামলার জটটা আমরা আর একটু হ্রাস করতে পারতাম, এবং প্রিকেস মিডিয়েশন গুলো যদি আমরা এনফোর্সিবল করতে পারি, সেই ক্ষেত্রেও মামলা জটটা হয়তো আর একটু হ্রাস করতে পারতাম। থ্যাংক ইউ স্যার।
আপনার শেষের প্রশ্নের জবাব ভেরি সিম্পল। We cannot make law. Law has to be made by Parliament. Pre-caseর যে কম্পাউন্ডেবল অফেন্স মিডিয়েশনে আসবে কি না আসবে, আমরা তো নতুন করে আইন বানাইতে পারবো না। আইনে যা আছে আমাদের সেই আইনই প্রয়োগ করতে হবে। The other part of your question with regard to the lady, again, sad but true that if the case does not go to court, the piece of paper that she has in hand is not worth a lot. Only thing she can do is if she has the physical power, মানুষ বল যদি থাকে, মানুষ বল বললাম, তাহলে she can stick to her ground and let the other party go to court. And there she will have this piece of paper to prove her case. Otherwise, your only alternative is to advise her to file a suit. If she can't afford it, that is the sad story of many thousands of people in our country. And unless the law is changed, there is no other way that we can help them. We can only do what is available and possible within the parameters of the law. Unless Justice Geeta Mittal can give us some other idea of how this lady, I don't know whether you got this story. The story is very simple. That
I struggled to understand, but I could understand. After the beginning, I couldn't understand one word.
It's the case is the lady came to the legal aid officer, and in mediation, she was able to get an agreement from the other side. But the other side did not comply with the agreement, and she can't afford to go to court because of the compulsory ad valorem court fee that she has to pay if she goes to court. And unless the other side goes to court, this piece of paper she cannot produce in the court. So there is the dilemma.
That's exactly what I spoke about, the legislative vacuum, enforcement and execution of agreements which are reached in mediation or any other alternate dispute resolution at a pre-litigation stage, we have to provide for a mechanism, Something like the law requiring general power of attorney be filed in the court, can be filed, registered, or a will can be filed with the registering authority. So, we have, and what is the biggest gap in all the jurisdictions is that we lack legislation on mediation. In India, we have been talking of a bill, and all kinds of people and parties and authorities have proposed several bills which are pending with the government. But I'm told the dilemma there is as to how can we give dispute resolution authority to non-court players, So this has to be resolved. But without an effective legislation, it's just an agreement, which between two private parties.
Yes, you see, this lady can't afford a lawyer. If I was a lawyer, I would advise her to file a case under Section 110 of the Code of Criminal Procedure.
Former paupers?
No. This is threat to peace.
I see. Oh.
Or even a case under Section 145 of the Code of Criminal Procedure.
CRPC.
In case of proper suit. স্যার প্রপার্সনের ক্ষেত্রে লিগ্যাল এড অফিসার অ্যাপয়েন্ট করতে পারে। মামলায় যখন জয়ী হবে তখন লিগ্যাল এড অফিসার বা প্রপার্সনের ক্ষেত্রে জয়ী হওয়ার পরে সে টাকাটা আদায় করতে পারে সরকার।
So there is another option. So you have 2 or 3 options, not without remedy altogether.
What was this option?
Thank you.
The pauper suit was one, and the other one, as I suggested, the criminal procedure, because if she goes to the police and says, I need protection, and here is a piece of paper which shows that I have rights. So, admitted position.
Thank you, ladies and gentlemen, for a very interactive, communicative session. Now, this is the time for lunch break, and we will again meet in the same platform using same ID and password after lunch at sharp 5 p.m.
Anita, maybe 2:10.
Okay, 2:10 p.m.